So we have seen there are many conflicts arised between fundamental rights and directive principles of state policy. There are many cases in Supreme Court regarding this issue. What if there is any clash between directive principles and fundamental rights? We say, Dr. B.R. Ambedkar said that fundamental rights and directive principles are novel features of the Constitution. So the government should not make any difference between fundamental rights and directive principles of state policy, because they together form a novel feature, and in every policy of the government there should be a reflection of both fundamental rights and directive principles. So we consider that fundamental rights and directive principles of state policy are not contradictory to each other. Rather, they are complementary to each other. They are supplementary to each other. They are subsidiary to each other. So both fundamental rights and directive principles, they shall go hand in hand. They shall go hand in hand. Then only there will be a sense of equality, or many ideals of the preamble would become reality. So in times of conflict between fundamental rights and DPSP, in general case, fundamental rights would prevail. Reason being, fundamental rights have given enforceability, that is, they are justiciable in nature. If there is a violation of fundamental rights, that particular citizen could move court. That is not in the case of DPSP. DPSP are not justiciable. They cannot be enforced. There are many reasons for not making DPSP justiciable, because India does not have that much of resources because of diverse country. We have lot of diversity, multi-religious countries. We cannot enforce all these directive principles of state policy. But gradually we are trying to bring certain provisions in DPSP into fundamental rights. For example, by 86th Constitutional Amendment Act, we have made right to education. Earlier it was under Article 45 of DPSP. Now it has brought into fundamental rights under Article 21A, because the state knows, or a common understanding is, without proper education, without skill development, the country will not progress. That is the reason why we are providing free and compulsory education to the children. Gradually, we may also bring certain provisions from directive principles of state policy into fundamental rights. But as of now, if there is a clash between fundamental rights and DPSP, obviously the fundamental rights would prevail. That doesn't mean that DPSP are inferior. Both fundamental rights and directive principles of state policy they have equal importance. The state should give them equal importance while formulating any policy or by bringing any law. So what if there is a conflict? There are many cases in the court. In Champakam Durai Rajan versus State of Madras, the Supreme Court has reiterated that whenever there is a clash between FR and DPSP, the fundamental rights would prevail. As I said, because they are enforceable in the court, they are justiciable, that is the reason fundamental rights would prevail in times of clash between fundamental rights and directive principles. This was the judgment given in Champakam Durai Rajan case. Even in Golaknath case, there was the judgment by the Supreme Court that both fundamental rights and DPSP should be given equal significance by the state. But obviously, because we have fundamental rights, we have Article 32, which gives the power of enforceability. So we have right to constitutional remedies under Article 32, and under Article 226, this is the power to issue writs by Supreme Court and power to issue writs by High Court. So fundamental rights are enforceable. But for any state action, both fundamental rights and DPSPs should reflect, because DPSP, as we say, they are instrument of instructions. They instruct the state government in framing the policy. DPSP are more concerned with a community or society, whereas fundamental rights are concerned with individual person. So whatever welfare scheme the state brings are influenced by the provisions which are mentioned in Directive Principles of State Policy. We say fundamental rights are restriction in nature. Fundamental rights restrict the state in bringing certain law which takes away the fundamental rights of a citizen. But Directive Principles of State Policy will guide the state. They are more positive in nature. DPSP will guide the state in bringing such laws which affects all sections of the people positively, to establish a socialistic society, to establish a welfaristic society. The state need to follow the provisions mentioned in the Directive Principles of State Policy. So we have Golaknath case, where generally we have a dispute regarding property. Here in this case, the parliament, there was a clash between parliament and Supreme Court. Obviously, the Supreme Court says that the parliament under Article 368 cannot amend fundamental rights. That is, Article 368 gives only the procedure of amendment. What is the procedure followed in amending the constitution? But Article 368 does not give power to modify or take away the fundamental rights or to amend the fundamental rights. This was the judgment made in Golaknath case by Supreme Court. But later in Keshav Nanda Bharati case, the judgment was reversed. The Supreme Court said that the parliament has the power to amend fundamental rights, to amend the constitution, but it should follow the concept of basic structure. This we will discuss in Keshav Nanda Bharati case. So in Golaknath case, there was a clear judgment that parliament do not have power to amend fundamental rights. Later in Keshav Nanda Bharati case, that judgment was reversed. The Supreme Court overruled its case or judgment in Golaknath case and said that Parliament can amend any part of the constitution, including fundamental rights. But it says that there is a basic structure. There is a basic structure which shall not be violated by the Parliament. The basic structure should not be touched when there is a process of amendment. In again, after Keshav Nanda Bharati case, in Minerva Mills case, the Supreme Court has defined basic structure. It has reiterated again that yes, Parliament has the power to amend any part of the constitution, but without disturbing the basic structure. Here when we say basic structure, it is generally like in preamble we have mentioned India is sovereign, socialist, secular, republic, democratic state. So obviously this is a basic structure. The Parliament cannot amend the word secularism, though they have added secularism by Constitutional Amendment Act, but the basic structure like federation, it cannot modify a basic structure. So it was clear in the verdict given in Keshav Nanda Bharati case that Parliament has the power. Parliament can amend according to Article 368. By the power of 368, Parliament can amend any part of the constitution, but basic structure should not be disturbed. That is how in for amendment we have repealed Article 31, which was right to property. Right to property was mentioned in fundamental rights, that we have repealed because we have to bring many agrarian reforms to eliminate zamindari systems, raitwari systems, and we have provided this in legal right, which has we have made just a legal right. This is not enforceable in the court. So that was a decision in Keshav Nanda Bharati case. As I said, in Minerva Mills case, the same judgment was reiterated. The Supreme Court said that though the Parliament can amend any part of the constitution but should not disturb basic structure, and basic structure was defined by Supreme Court in Minerva Mills case. As of now, it is a clear-cut picture that Parliament as a sovereign authority, as a ultimate authority in framing law, in bringing any policy, but it should keep in mind that there should be a thing like basic structure which should not be disturbed. So by judicial review of the court will generally look that the constitution is not violated by any policy by the state. So where we have implemented this directive principles of state policy, we have many legislations, many laws related to this. So we have generally implemented in land reforms. As we said, the basic objective behind repealing of right to property is land reforms. So land reforms is, earlier in zamindari system, a single person used to have hundreds of acres of land. But the policy of the government, as we need to establish a socialistic pattern of society, the state should distribute the land to the poor, to the underprivileged section of the people. So we have brought land reforms. So this has brought many policies like abolition of intermediaries like zamindars, jagirdars and inamdars. We have brought many laws which affects the tenancy reforms. Tenancy are the people who work on land which generally they do not have. They are tenants. So we have given security to those tenants who work on the land, agricultural land. We also have brought many policies which distributes the surplus land to the needy people. So what we say is the provisions mentioned in the directive principles of state policy has directed the state, has guided the state in bringing several law or bringing several policies which affects the livelihood of the citizen. So we also say that we have 73rd Constitutional Amendment Act. This is again under Article 40 of Gandhian principles, that says that to organize panchayat systems, to strengthen the administration at grassroots level, to prevail democracy and governance at grassroots level. And hence we have, by this act, 73rd Constitutional Amendment Act, we have created a new part, that is Part 9, Panchayats. Now we have 3-tier body in Panchayat, that is Gram Sabha, Mandal Parishad and Zilla Parishad. There shall be a periodic election for that every 5 years. There is a system of reservation also. Because to strengthen the lives of the people at rural area, we have brought this Constitutional Amendment Act and made Panchayats a constitutional body. So 3-tier Panchayat Raj systems. We need also study Article 74th Constitutional Amendment Act, which talks about urban local bodies. Panchayats are rural local bodies, RLBs. So this, as we have mentioned in Article 40, this was under DS, Directive Principles of State Policy, DPSP. So we have given a constitutional status. So gradually we need to know that whatever provisions are mentioned in the DPSP will guide the state in framing such policies to establish an egalitarian society, to make sure that the wealth is distributed among all sections of the people, to prohibit the concentration of the wealth in the hands of few, to develop all the sections of the society, and also to improve all the things like we have primary sector, we have secondary sector, we have tertiary sector. So the government should take steps to give equal importance to all the sectors so that the growth is balanced, the development is comprehensive. We have cottage industries. This we study in Gandhian principles. So we have many government brought policies which improves village industries. Khadi and Village Industry Commission is there, which was established by the Act of the Parliament. We have Handicraft Board, Silk Board, Coir Board. This type of cottage industry will strengthen the people economically at grassroots level, that is at village level or at lower tier level. We have many programs which emphasizes, which strengthens the economic and social development of the citizen. In terms of education, as we have already discussed, we have this Article 45 is under DPSP. We have brought this under fundamental rights by amending Article 21A or by inserting Article 21A. We have brought right to education. This is Right to Education Act 2009, which makes compulsory the child should be in schools under the age of 6 to 14 years of age. So rural area development programs, these are important. These are also influenced by the provisions under DPSP. So we have programs like CDP, Community Development Program. We have IRDP, Integrated Rural Development Program. We have MG Narega. This is Mahatma Gandhi National Rural Employment Guarantee Act, which provides work, compulsory work to the people. So all these programs of the government will enhance the economic status of the people. The government is responsible to provide jobs to their citizens. That also decreases the level of unemployment. And we could ensure that the development is reached to all sections of the people. So this acts of the state government or central government will provide the decent standard of living. This increases the standard of living of the people. This is again in terms of health. There are many policies of the government which focus on the health of the people by establishing primary health centers, by creating government hospitals, by giving medicines available to the needy people, affordable treatment. So we have schemes like Pradhan Mantri Gram Swasthya Yojana. We have National Rural Health Mission. So these are very important flagship programs by central government which enhances the health of the people. So all these things are mentioned in the DPSP, and the government or the state will get influenced by the provisions of the DPSP and ensure that those provisions are implemented through such policies, be it health policy, education policy, manufacturing policy, defense policy, or any such policies. The state is influenced by the provisions mentioned in the DPSP. Though we say that directive principles are not enforceable, that does not mean the state will neglect the provisions of DPSP. The state has to consider the provisions of DPSP very seriously so that we achieve the concept of welfaristic state. No political party will ignore before the elections to insert many of the provisions of DPSP in their manifesto, because people will vote a party depending upon how much importance they are giving for welfareistic programs. You take any schemes like pensions to the old age people, scholarship to the students, pensions to the disabled people, or help public assistance or financial assistance to unemployment, or giving bank loans to the needy people. So all these policies, free drinking water, free electricity, insurance for crops, minimum support price, so all these policies are welfareistic in nature. So the citizen will make sure that before voting any political party, all these things have to be included in their manifesto. On the basis of their manifesto only, they would come to power. So all the political parties will ensure that the DPSP is given priority. So when we talk about environment, there are many laws which have brought by the state, like the Wildlife Protection Act, which ensures that the wildlife are protected, conserved and preserved, because we have many international conventions here. The Forest Conservation Act, the Environment Protection Act. On these lines only, we have developed many things, like we have conserved in terms of wildlife sanctuaries. We have placed many tiger reserves, bird sanctuaries, zoological parks. So all this makes it mandatory now, because we have a law. We have a law, and any against this law will be punished. So poaching is prohibited. It's a criminal offense. Cutting trees in protected areas are prohibited. The environment should be protected. You cannot just go and build an industry there. You cannot set up a manufacturing industry which, by the pollution of such industries, the environment is disturbed. We have Green Tribunal, which will generally gives permission to establish such manufacturing industries. So many laws are there which have influenced by provisions of DPSP. In terms of heritage preservation, we also say that the ancient and historical monuments need to be protected. So we have Archaeological Sites and Remains Act of 1958. This is important, where the historical monuments are preserved and protected because they have a national importance. We will be discussing directive principles of state policy based on Gandhian principles. So Article 40. What is Article 40? We keep Article 40 in Gandhian principle because Article 40 talks about Panchayat Raj. We describe Article 40 in terms of panchayats, that is local government, local bodies, local units of government. So organize village panchayats. As Gandhi said, India lives in villages. Until and unless we have a development in villages, no country will progress. So right from agrarian, animal husbandry or such activities should be strengthened at village level. Villages should make participation in the governance. So they should be given power to organize themselves and to democratically participate in the governance and in the government as well. So Article 40, we have seen the 73rd and 74th Amendment Act, Constitutional Amendment Act, gave constitutional status to rural local bodies and urban local bodies. So we have in Part 9, it is been mentioned regarding panchayats, and Part 9A municipalities. So, as we know, the state should keep in mind while framing any policies the directive principles of state policy. The DPSPs guide the state in formulating any policies or bringing any law. So this article we have seen that the mention of panchayats has become a reality. That is, now we have given a constitutional status to rural bodies and urban bodies. So panchayats need to be given much importance regarding the local government and making them an autonomous body. That is Article 40. In Gandhian principle, we also see Article 43. Article 43 suggests promotion of cottage industries. That is, even this strengthens the local bodies. Local bodies in sense, we have in panchayat system, we have 3 tiers of government. That is Gram Sabha, we have in intermediary level Mandal Parishad, and at district level Zilla Parishad. So cottage industries should be promoted at grassroots level. So what is cottage industry? Any industry using local resources, using local people, a setup should be built where there is a manufacture of different kinds of products. That is based on MSME. We have micro, small and medium industries. So the government should take steps to promote local cottage industries involving local people and local resources. This concept will strengthen the economic activity, or the economically the people will be more strengthened. So we suggest that the steps taken by the government in promoting cottage industries will obviously decrease unemployment. Unemployment will be reduced. The people will get money in their hands. There will be a continuous cycle of demand and supply, consumption and production. So again we say it will also promote the living standards of the people. It will increase the living standards of the people. That is why we have taken this Article 43 in Gandhian principle, because Gandhi said that to have a vibrant democracy, to grow the nation, for the development of the nation, the local people or the local bodies should be given powers. They should be made more autonomous. The people should be made to participate in the governance of the country. So that is promotion of cottage industries. Here again 43B. Here we have seen village panchayats, cottage industries. When cottage industries will be successful? When there is a group of person, who come together and establish some sort of industry. For that, the government need to provide them with economic incentives in terms of loans, in terms of subsidized electricity or things like that. So cooperative societies should be strengthened, and these cooperative societies should be formulated voluntarily. Voluntarily, people should come together, form a cooperative society and start any entrepreneurship. There in that organization or in that society, the function should be based on autonomous principles. So government should not interfere in day-to-day administration of such cooperative societies. The people should be given power, autonomy in deciding the rules and regulations of such societies. There should be a democratic control. In the society, we have a periodic elections in any cooperative society. one among them will be elected as a leader, and there will be a democracy kind of decision making in cooperative societies, and the management should be professional, so that the future of these cooperative societies will see the success. So we say Article 43B promotes cooperative societies, giving them autonomous power to function. Article 46. In Gandhian principle, we say Article 46 is to promote educational and economic interest of weaker sections. Because when we say directive principles of state policy ensures a socialistic pattern of society. Here when we say socialistic pattern of society, the government has the responsibility to distribute whatever material resources they have within the state. The material resources should be distributed among the people. So concentration of the wealth should be reduced. So the wealth should not be in the hands of few people. So when we say promotion of educational and economic interest, it means like we have seen many examples. We have schools, residential schools at village level. We have colleges, government run universities. So we also have minority colleges. So the government should take steps to provide education for the weaker sections of the society free of cost. No person should be left out of the education system, because we know the problem of illiteracy. For any country to grow on modern lines, they have to be well educated. The skills should be improved. For any industrial countries, we have seen the skill is more important. So here educational and economic interest. If government provides education, definitely the citizen will be empowered and he will try to earn. So the economic condition of the citizen is related to education. If a citizen is skilled, well educated, then they will have good opportunities and they would do better economically. So that is the responsibility of the government, to provide free education and give opportunities of employment. This Article 46 guides the state government to bring many policies related to education. When we say public health, this is Article 47. It is the responsibility of the government, or the state shall take steps to increase the health standards of the people. So when we say health standards, right from providing safe drinking water, nutritious food, good quality of air, good conditions, good environmental conditions, good roads, good connectivity, whatever. So it is the responsibility of the government to provide public health, to improve public health. This article also guides state government or central government to provide health facilities to the people, taking public health very close to the people. That is, construction of hospitals, government hospitals, or primary health centers at rural and local areas, that is urban areas. Bringing medical facilities close to the people, affordable to the people. So all these steps are taken because directive principles of state policy guides the state in formulating of the policies. So it is very important to spend more money on education and health. This should be given more priority by any government in the state. So generally speaking, health and education are very important, and it should be more accessible and affordable by the people. We have seen this, the importance of health, when in the time of pandemic, many people could not afford the corporate hospitals charges. So government should take active steps to promote government hospitals and to provide free health to the needy people, poor people. That is the importance of Article 47. Article 48 talks about prohibiting of slaughter of cows. So, slaughtering of cows, which are milching animals, we get milk from these breed. So, the government should take steps to prohibit the slaughter of cows, calves and other milching animals, milk giving animals, so that the production of the milk is increased. For the population of our country, it is necessary that we increase the milk production, and it also balances the ecology. So Article 48 emphasizes on protection of such breeds which gives milk, and also for the improvement of such milching animals. So we know many breeds are there. Scientifically, there are many breeds which gives lots of milk. So on scientific lines, we need to improve that production. So that was DPSP based on Gandhian principles. When we say Article 48, we also have Article 48 in liberal and intellectual principles also. This we will be discussing. So now we have directive principles based on liberal and intellectual principles. Article 44. This is Uniform Civil Code. We know we have many different codes like Hindu law, Shariat law, that is Muslim law, and other laws. But because we have a united system of judiciary, here there is a need to have uniform civil code. Though we did not made it mandatory, but the DPSP has said that there need to have a uniform civil code which is applicable throughout the territory of India. So on these lines only, we have removed the system of triple talaq. So uniform civil code under Article 44 is very important. It brings a uniformity in the territory of India in terms of code, that is civil code. When we discuss Article 45, it gives importance to early childhood care. We know Article 45, by this we have made the right to education. Right to education, this law has been made, and now right to education is under fundamental rights under Article 21A. So the government says that any children between the age of 6 to 14 years of age should have a free and compulsory education. So this under DPSP, any child under 6 years should be given special care by the government and also by the parents. They should create a good environment for the overall development of such child. So this is early childhood care and education for the children until they complete the age of 6 years. After 6 years, they have a formal education. From 6 to 14 years of age, there is a free and compulsory education under right to education, which is a fundamental right. Any state or its action violates this article, that is right to education, then the citizen could go to court for the enforcement of this fundamental right. So early childhood care in education, this is also very important, where a children will be given free vaccines. In central government's program, we have Indra Dhanush, where the children will be given free vaccines, because childhood care is more important. They have to be protected from dangerous diseases. So Article 45, which guides the state to bring such policies which affects the children positively. Here in Gandhian principle, we have studied Article 48, where the slaughtering of cows are prohibited. Here in this article, the agricultural and other sectors like animal husbandry should be on modern and scientific lines. We have to organize agriculture and other related activities on modern and scientific lines. So, implementation of machineries using modern techniques in animal husbandry are the effects of this article, Article 48. So, any state should take such steps to organize the agriculture and other related activities on modern lines. So, this is very important in our primary sector, because we know in India, primary sector is the backbone. Many things have to be changed, at least now. So, still India follows old system of farming. So, the government should take active steps to replace with modern techniques of farming. So, distribution of tractors, implements and other techniques like drift irrigation, using less water for more production. So, all these techniques should be made available to the farmers. They have to be given loans and subsidies on these machineries. So, this will improve the production and definitely adds to the growth of GDP. So, Article 48 is important to strengthen the primary sector, and also it will strengthen the manufacturing sector too, because this sector, primary sector, supplies raw materials. So, it is the responsibility of the government, it is the responsibility of the state to organize agriculture and other related activities in modern lines, modern and scientific lines. Article 48A, amended one. This article talks about protection of environment. So, it is also the responsibility of the government to protect the environment, to maintain the balance, ecological balance, because it is mandatory or it is advisable that at least 33% of the land should be covered with forest. We have bringing many policies regarding this. We have afforestation policy like social forestry, community forestry, where we grow plants and trees. In Telangana government, for example, we have a program of Harita Haram, where we plant trees every year. So, this will enhance the forest cover, which also plays an important role in good production of the agriculture. That is, it will enhance the rains, monsoons will be increased. So, it is the duty of the state to protect environment, and whatever forest we have, the natural resources should be protected, should be preserved and conserved. We also say that not only environment and forest, the wildlife should be protected. So, wildlife are the rich resources of any nation. It is the responsibility of the government or state to protect wildlife. In this case, the government has many policies like wildlife sanctuaries, tiger reserves, elephant sanctuaries, bird sanctuaries. We also have zoological parks, that is zoo parks. So, these all steps of the government will definitely brings the wildlife safety, and there is a in situ and ex situ protection. So, it is very important that the environment should be preserved and conserved. so that there prevails a balance and equilibrium between the ecological systems. So Article 48 talks about improve in environment, forest, safeguarding forest, and also wildlife. So this is Article 48A. Article 49, it is the responsibility of the state, or the state shall take steps to protect monuments which has historical background. Those monuments which are standing since ages should be protected and preserved. For example, we have Golconda Fort, we have Charminar. So all these monuments are protected by the state. We have to protect them because the coming generations should know about the history. So all these monuments are rich in heritage, and every state or the government should take steps to protect and preserve such historical monuments which has artistic interest or historic interest. So we generally see many agencies, government agencies like archaeological department will try to preserve rich heritage. There may be temples, there may be monuments, there may be some sort of historic and archaic monuments. So the state will protect such monuments, and it is also mentioned in our fundamental duties that every citizen shall show respect towards those monuments. Even it is the duty of the citizen to protect such historical monuments. Article 50 talks about the separate judiciary, that is separation of judiciary from executive. So judiciary and executive need to be separate. This is for the specialization purpose. We need to separate judiciary from executives. We have tribunal systems. Example for this. So executive should not be mixed with judiciary. So this is Article 50. On international and Western principles, we see that for any country, maintaining cordial relations, maintaining friendly relations with other countries is also important, because we are living in a world which is connected, market connected, which have culturally connections. So all these things should be maintained by having a friendly relation with other countries also. We have a diaspora which live in other countries. So economic relations are also important. We also sign many agreements with many international agencies like United Nations, like UNICEF, World Bank, IMF. We also have many bilateral and multilateral agreements. We have many groups like World Trade Organization, World Health Organization. We have multilateral groups like SAARC, BRIC, G20, ASEAN, etc. So to respect such agreements and to adopt those conventions, our country should have a friendly relation with other countries also. Here Article 51 says, it declares that the state shall establish international peace and security. How? By maintaining just and honorable relations with other nations. For fostering respect for international law, we have international law, and we will enter into treaties or agreements with other countries. We need to respect such agreements. We should encourage settlement of international disputes by arbitration. This means no country could afford continuous clashes with other countries or neighbor countries, because it is against the larger interest of the people. it would affect on development of the country, both economically and politically. So we have to settle those disputes which arise due to many reasons. They have to be settled by arbitration. Arbitration is a method in alternative dispute resolution, ADR. So we have international justice, ICJ. We have methods like arbitration, reconciliation and mediation. By the process of arbitration, many disputes have to be settled so that there prevails a peace and tranquility. So all these principles guide the government in framing policies for overall development of the nation. So as we said, directive principles are very important, which guides the state government or state, be it central government or state government, in framing such policies which upholds the interest of the nation. So we have categorized these directive principles, though it is not mentioned in the Constitution, but for a general understanding, we have categorized these directive principles into 4 categories. So one is socialistic principle, Gandhian principle, liberal intellectual principle, and principles based on international and Western laws. So we have added many things in directive principles of state policy by various amendments. We'll see what are those articles which have added by constitutional amendments, which are not there in original constitution. So 42nd Constitutional Amendment Act is very important. It has changed, modified and also inserted few provisions in directive principles of state policy. We have Article 39A. This is to provide free legal aid to the poor people. As we have mentioned in our preamble, justice, socio-economic and political justice should be provided for every citizen. Generally we see, as we have lot of poverty, illiteracy in our country, most of the people could not afford the expensive judicial process, and to provide them the opportunity for justice, the government or the state should take such steps as providing free legal aid. So justice should not be denied to any citizen just because they cannot afford the judicial process. They are not kept away from the justice. So the state government should take steps to provide free services, free legal services. That was added by 42nd Constitutional Amendment, Article 39A. Article 39F is also added. It says the children should be given a chance to grow. They should given an opportunity to grow. The state should take active steps for the development of the children. So below the age of 6 years, the state should take such steps, right from taking public health closer to the people, affordable medicines or affordable public health in terms of primary health centers. So it is the responsibility of the state to provide children a chance to grow. 43A, it is also added by 42nd Amendment, where we say the workers are made to participate in the management of any organization. They should have a sense of participation. That satisfaction will make them to work more positively. So there should be a participation in between workers and the management. Workers should be asked or taken suggestions by the management. they have to have a good relation between employee and employer. So this participation is on the lines of democracy. Any worker should feel that they are the part of such organization in which they are working. So this is very important, which has given a good chance to work for the workers. So Article 48, this we have seen, added by 42nd Amendment Act. It says to protect and improve the environment. The environment should be improved, the forests should be preserved, wildlife should be preserved. So the state should take such steps in the protection, conservation and preservation of environment, forest and wildlife. So by 44th Constitutional Amendment Act, we have inserted few things. That is Article 38. This says the state should strive to minimize the gap, or the gap should be reduced between haves and have-nots. There should be a lessened gap. The inequalities should be reduced. This is why we say socialistic pattern of the society. The government or the state shall ensure that the distribution of wealth and no concentration of wealth in the hands of the few. The wealth should be distributed among the community, among the common people. This enhances the overall development, regional wise, region wise. So all the sections of the society, be it agrarian class, industrial workers or people living in cities, everyone should have equal development. Otherwise, there will be an unbalanced development. When this equilibrium is missed, then there will be an unbalanced development which could lead to chaos. So the state shall strive to decrease the inequalities. The gap should be reduced. So the state will minimize the economic inequalities. Again, inequalities in terms of status, facilities and opportunities. This means the state should take active steps to provide opportunities for the people in terms of employment, in terms of giving facilities. So by providing loans, by providing subsidized implements, the government would improve the living standards of the underprivileged section of the society. So it should be proactive step by the government, special focus on such sections of the society where generally they are lacking, or the development, the fruits of development are not reaching to the section of the people. So it is the responsibility of the state to take certain steps to improve their living standards. So many government schemes we have seen will make such sections of the people participate in the system. So giving loans by the banks, like we have Mudra scheme, by giving loans to self-help groups, by giving loans to Dalits and tribals. So all these steps will enhance their living standards, and obviously the development will be more comprehensive. So we have seen that in our preamble we mentioned that we should take steps on establishing a socialistic pattern of society, that is socialism. To make it reality, the state shall take steps to improve the living standards of all the sections of the people. So we have eliminated right to property because this was causing lot of problems. Many cases are there in the Supreme Court regarding right to property. So we have repealed right to property, which was under Article 31 and also under Article 19 Clause 1F. We have made the right to property as an ordinary right or a legal right. So this has ensured that the wealth is distributed among the common people or community. So this was inserted by 44th Constitutional Amendment Act. 86th Amendment Act. We know that Article 45, to provide education to the children, we have made compulsory education, that is right to education, under Article 21A. 21A mandates that every citizen or every child between the age group of 16 to 14 years of the age should be given free and compulsory education. So this Amendment Act, that is 86th Amendment Act, has made Article 21A, inserted Article 21A, which guarantees or which makes it compulsory for the age group of 16 to 14 years of child to go to school. Directive Principles of State Policy. This topic, Directive Principles of State Policy, is enshrined in Part 4 of the Constitution, and this goes from Article 36 to Article 51. So fundamental rights, as we have seen, are from Article 12 to Article 35, which are in Part 3 of the Constitution. The extended part is Part 4, that is Directive Principles of State Policy. Together, fundamental rights and DPSP are regarded as novel features of the Constitution. So Dr. B.R. Ambedkar has insisted that both fundamental rights and DPSP together are supplementary for achieving the welfaristic goal of the society and also for the development of individual as well as socialistic nature of the society. So Directive Principles of State Policy, వీటిని మనము నిర్దేశక నియమాలు అని కూడా అంటాము. So this article are the basic for any state. This article provides the foundation for any state for the formulation of policies. Why we call these as directive principles? Because they direct the state in the formulation of any policy. They becomes a yardstick to gauge the development of the nation. So directive principles are important and they are supplementary to the fundamental rights of the Constitution. So we need to know from where we borrowed this concept of directive principle of state policy. Originally, DPSP as a concept is a Spanish one. So Spanish country, in Spain we had this DPSP. Ireland borrowed from Spain and we have borrowed the concept of DPSP from Irish, that is Ireland. The source of the concept of DPSP is from Irish. What we have borrowed is from Ireland. So the directive principles of state policy together with fundamental rights are very important part in the Constitution, which gives a structured development to the nation. So we'll move to the importance of directive principles of state policy. So Part 4. In Part 4 of the Constitution, we have directive principles, and these are from Article 36 to Article 51. As just to remind, fundamental rights are in Part 3 of the Constitution from Article 12 to Article 35. So directive principles will guide any state, will guide the state in formulation of their policies. So originally we also call these, that is DPSPs, as instrument of instructions. So they are also called as instrument of instructions, that is they instruct the state in preparing such policies needed for the governance. So as we know, governance is the practical part of the government, that is the administration. For any country to progress, we need to have a very fine administrative agency. So implementing of the policies are also very important. So right from formulation to implementation, DPSP helps the government to frame such policies which could uplift the underprivileged section of the people, and there is a society where there is minimum inequality. So all justice, that is socio-political and economic justice, is upheld. So these instrument of instructions, as we say, directive principles, will guide the state in formulating the policies which are important in the governance, that is in running the government. So what is Article 36? As we said, DPSP start from Article 36 to Article 51. So we need to understand the Article 36. Every article is important here, as we have did in our fundamental rights. So Article 36 defines the state. It has defined the state, just to put simply, because we have already discussed Article 12 in fundamental rights. The state is defined in Article 36. As every time we use this word state, state shall, state should bring such laws. So what exactly the meaning of state is? So here when we say state, it is parliament and the union government, that is central government, state legislative assembly and state governments. We have local governments, that is rural government, urban government. We have a system of panchayat raj, municipalities, etc. And various corporations under the government, like we have corporations, aided corporations funded by the government. We have other authorities, that is other bodies or agencies which are given status in the constitution. We also call them as constitutional bodies. And we have many statutory bodies, that is they are not mentioned in the constitution, but they are created by the executive or maybe created by the parliament. So all these bodies which have a statutory force is defined under the Article 36, that is state. So when we say the state shall, that means any body, be it central government, state government, local government, or any other such agency which has a statutory force, that is defined in Article 36. So the definition of state, is defined in Article 36. It is similar or it is same as defined in Article 12. So Article 12 is the first article in fundamental rights which has defined the state, what all includes in the state. And Article 36 also defines the state in same manner as defined in Article 12. So next article is 37. So this article defines or explains about the applicability of DPSP. It is Directive Principles of State Policy. Here we say that directive principles are not justiciable. They are not enforceable in the court. Very important difference between fundamental rights and directive principles of state policy is fundamental rights are enforceable in the court. That is, if any action of the state violates the fundamental right of any citizen, then that aggrieved citizen can move Supreme Court under Article 32 and can move High Court under Article 226 Clause 1. So that is the importance of justiciable, that is enforceability of fundamental rights. Unlike DPSP, here when we talk about DPSP, directive principles are not enforceable by the court. So if any person who has not got the development from directive principles, or if someone has belief that they have not been part of this development, they cannot go to court saying that these are mentioned in directive principles but state has not taken any action for their implementation, because DPSP are not enforceable. No one could go to court suggesting that DPSP are not implemented by the state. But one thing is clear, DPSP should be the foundation, or it should be the guiding principle in formulation of the policies. The state should consider directive principles of state policy as a basic element in whatever policy they frame. So policies are like various types. We have defense policy, we have educational policy, health policy, agricultural policy, industrial policy. Any policy which the state is formulating should have inputs from directive principles of state policy. So basically, what is the major thing about DPSP? Why it is so important that every state and its policy should be based on these features of DPSP. So DPSP primarily is enshrined in our constitution, or we have made part of the constitution because we have a plan. We have a plan to establish a socialistic pattern of society. So this socialistic pattern of society where the state will work for the welfare of the people. So welfaristic approach of the government makes it important or significant that they follow the principles which are part of directive principles of state policy. So our founding fathers of the constitution also, before we got independence, have the thought of establishing a society based on socialism. Though we have not taken the socialism as a Western concept is practiced, we have a unique style of socialism. As we say, our socialism is establishing a socialistic pattern of the society. So we generally tend towards Fabian socialism. I repeat, it's a Fabian socialism. This concept of Fabian socialism says that whatever the resources of the nation is belong to the common people or a community, and the process of development or the fruits of development should reach everyone. It's a gradual process of development. Every section of the society should grow equally. There should be a very minimum gap between haves and have-nots. So, to reduce inequality, we tend to, that is, the government in its policies or in its work, it should be the motive of the government to provide basic facilities to every section of the society. So that is Fabian socialism. So Article 37 here, when we talk about Article 37, it is not justiciable in the court. That is the applicability of directive principles of state policy. We have criticized in our previous classes, we have criticized fundamental rights. One point we need to remember is fundamental rights have more political power or political freedom. That is where we have criticized that fundamental rights do not emphasize or do not focus on social and economic concepts. So that has been the reason why directive principles of social policy have gave importance to socio-economic independence. That is, it works on the development of the community on the basis of socio-economic perspective. So here ensuring socio-economic justice is also important for the overall development of the society and individual as well. In fundamental rights, we have, as critics say, neglected socio-economic justice. It has focused more on political justice. Political justice without socio-economic justice would be rather a failure of the society, because ultimately it is the basic thing. It is the welfare of the state which needs the special focus of the government. Just not providing the right to vote, the government or the state should also ensure that every section of the people, men, women, old people, sick people, disabled, children, students, employees, every section of the society from all religions, from all regions, should be able to get the fruits of the development. That is how all three concepts, that is political justice, social justice and economic justice, should go together. That is when we could say that we have achieved justice, that is justice is prevailed. So all the three concepts should be given equal priority. So in directive principles of state policy, the framers of the constitution, that is, they have focused more on socio-economic justice. ఆర్థిక న్యాయం, సామాజిక న్యాయం మీద ఎక్కువ ఫోకస్ ఇవ్వడం జరిగింది. ఫండమెంటల్ రైట్స్లో మనకి ఓన్లీ పొలిటికల్ జస్టిస్ దాని మీదనే ఎక్కువ ఫోకస్ ఇవ్వడం జరిగింది. సో ఆర్టికల్ 37 క్లియర్లీ సేస్ ద అప్లికబిలిటీ ఆఫ్ directive principles of state policy. So we have a small difference. Just when getting into the DPSP in detail, we would be discussing a small differences between fundamental rights and directive principles of state policy. We also call this as instruments of instruction. They instruct the government or the state in framing governmental policies. So here fundamental rights have limited scope, because we know all the aspects of the governance are not added in fundamental rights. There are many things which we have left out, because India as a country cannot afford everyone the socio-economic and political justice. For that we need lot of resources, and because we have faced lot of tyranny, lot of exploitation under the colonial regime, we could not, at that time when we are framing our constitution, we have not added most of the features in fundamental rights, because fundamental rights are enforceable in the court. So many such things are left outside, and we have placed them in directive principles of state policy. That is the reason why I say that any government which formulates the policy should consider both fundamental rights and DPSP as well in framing its policies. They are equally important. It doesn't mean that DPSP are not enforceable in the court. The state will neglect it. If any state neglects directive principle of state policy, the real achievement will be just a dream. It cannot be a reality, because when we talk about welfare state, when we talk about socialistic pattern of the society, any policy should have the features which are mentioned in directive principles of state policy. So we have very limited scope in fundamental rights. Here scope is limitless. So when we read article 38, 39, 40, all those DPSPs, we could witness many things. It's very vast, diverse in nature. It focuses on all aspects of an individual, of a society altogether. So the scope is very large, wider than fundamental rights. So when we say fundamental rights, generally they are negative. Why we say negative or prohibitive? Because fundamental right stops state from bringing such law which could violate the fundamental rights or natural justice of any citizen. So every time the court will ask the legislature to not bring such laws which invalidate the constitution. If any law of the state or any legislation is against the spirit of the constitution or which takes away fundamental rights or abridges the fundamental rights of any citizen, such law can be declared as invalid. So we say fundamental rights generally put a restriction on the state for bringing such laws which are not inconsistent with constitution. So that is the reason why we call fundamental rights as prohibitive. They prohibits states action. As we have discussed many Supreme Court cases where an individual or a citizen whose fundamental rights have been taken away or abridged would move the Supreme Court or High Court saying that my fundamental rights has been taken away by the state and its policies. Then the Supreme Court will enforce those fundamental rights because it is the duty of the Supreme Court as a guardian of the Constitution, as a protector of the Constitution. Supreme Court enforces the fundamental rights. So states are always restricted from bringing such law or passing such legislations which are against the fundamental rights. When we say we have the right to freedom, right to free speech and expression, and if there is any policy by the government which restricts our freedom, then the aggrieved person will go to court. That is not in the case of directive principles of state policy. So we say fundamental rights are negative or prohibitive in nature because they put limitations on the state. The states are being restricted for passing such law. In directive principles, we say they are affirmative. Affirmative in sense, they add a positivity in the framing of the policies. The state should ensure that whatever policies they bring for the good of the people, for establishing an welfaristic society, they need to get influence from the directive principles of state policy. Here DPSP will guide the state. They will add an advantage in making the state to bring such policies so that every section of the society is happy with that and there is an overall development in the society. So the concept of egalitarian society or welfaristic society is upheld. So that is affirmative directions. These provide direction, or these DPSP are the instructions to the state in framing policies. So when we say welfaristic state, it is a very wider concept. ప్రజా శ్రేయస్సు కోసం ఒక ప్రభుత్వం చేయాల్సిన పాలసీస్ ఎలా ఉంటాయో, జనరల్గా ఇది మనకు అర్థశాస్త్రాల్లో కౌటిల్య మెన్షన్ చేసిన కొన్ని ఉంటాయి అర్థశాస్త్రాల్లో. సో టు ఎస్టాబ్లిష్ అ వెల్ఫేర్ స్టేట్, the government should strive to bring a uniformity, to lessen the inequality, to provide basic facilities to all the section of the people, to make the natural resources available to everyone, to decrease or to lessen the concentration of wealth in the hands of few members. So all these steps are taken by the government so that there is a socialistic pattern established in the society. So one important difference is they are enforceable. Fundamental rights are enforceable in the court. The court will order the state to enforce the fundamental rights, and at times the court will negate such law or will declare invalidate such law which is not consistent with the constitution. Whatever provisions we have in the constitution, if the law passed by the legislature is not consistent with the provisions of the constitution, then the court could declare such law as invalid. So that is where enforceability is important. We have discussed the types of writs. Writs are the tools by which the court enforces fundamental rights. DPSP are not enforceable by law. So court does not have power to enforce directive principles of state policy. Because directive principles are very vast in our country, as we have very diverse society, we have multi-religious society, we have caste system, we have a very diverse geographical entity too. So we cannot enforce all those provisions mentioned in the directive principles because we need lot of resources for that, be it natural resources, be it intellectual resources, and we need to get out of so many social evil things like illiteracy, poverty, malnourishment, etc. So we have not made DPSP as enforceable by the law. But important thing is, every policy of the state should be in line with or should be inspired by the provisions mentioned in the directive principles of state policy. So that is why we say fundamental rights are enforceable. They have very limited scope. DPSPs are not enforceable because there are many such provisions in the constitution where we cannot enforce every provision mentioned in the DPSP. So I say fundamental rights and DPSP are supplementary to each other. They are not contradictory. They are supplementary. They should go hand in hand together. We cannot demarcate that fundamental rights are enforceable, so more importance is given to FR fundamental rights, and DPSP are, because they are not enforceable in the court, they could be neglected. No government survives if they neglect directive principles of state policy, because as we know, we have a system of elections and every party before coming into power, they will have their manifesto, and many things are given or they have mentioned in their manifesto regarding their coming policies. వారు ప్రభుత్వంలో వస్తే ఎలాంటి పనులు చేస్తాము అనేది వాళ్ళు ముందస్తు వాళ్ళ మేనిఫెస్టోలో పొందుపరుచుకుంటారు. ఆ మేనిఫెస్టో ఏంటి? ఆ మేనిఫెస్టోలో చాలా వరకు డిపిఎస్పికి సంబంధించి ఉంటాయి. వెల్ఫేర్ స్టేట్ కానివ్వండి, ఒక వెల్ఫేర్ స్టేట్ కావాలంటే ఉచిత విద్య కానివ్వండి, ఉచిత వైద్య ఆరోగ్యం కానివ్వండి, మంచి రోడ్స్ ఎస్టాబ్లిష్ చేస్తాము, లేదంటే ఉపాధి కల్పన కలిగిస్తాము, లేదు అంటే పెన్షన్ స్కీమ్స్ తీసుకోండి, వృద్ధులకి పెన్షన్, నిరుద్యోగులకి పెన్షన్, డిసేబుల్ పర్సన్స్కి పెన్షన్, ఇలా చాలా వరకు వాళ్ళ మేనిఫెస్టోస్లో ఏ పొలిటికల్ పార్టీ అయినా పొందుపరుచుకుంటాయి. ఒక్కసారి ఎలక్షన్స్లో గెలిచి పవర్లో వచ్చాక అలాంటి వాగ్దానాలన్నీ నిరూపించుకుంటేనే నెక్స్ట్ టైం ఎలక్షన్స్లో ఓట్లు వస్తాయి. సో వీ కెన్ సే దట్ no government could survive if they do not implement directive principles of state policy, because people have power to change the government every 5 years, and no party will take any risk to avoid the provisions mentioned in directive principle of state policy. Even we have in preamble, we have mentioned in the preamble that we are a socialistic society. Our preamble says India is sovereign, socialist, secular, democratic republic, and justice of socio-economic political justice should be given. So that is the importance, and all those things are mentioned in DPSP. So it is not part of any government to avoid or to neglect the provisions mentioned in DPSP. Because they are not enforceable, that does not mean that they are given lesser importance. Both have similar significance. They go hand in hand. When I say fundamental rights and DPSP are supplementary to each other, they both go hand in hand. And one thing is, DPSP are not subordinate to fundamental rights. But there are many cases in Supreme Court where there was a discussion between the importance of fundamental rights and directive principles of state policy. The court rulings said that both have equal importance. The fundamental rights and directive principles have been given equal importance. The only thing is, when there is a question between the significance of fundamental rights and DPSP, or when there is a sense of conflict, then obviously fundamental rights would prevail, because we have given it a special status in terms of enforceability. First, fundamental rights would prevail when there is a conflict arises between fundamental right and provisions of DPSP. Otherwise, in normal circumstances, both need to be given equal importance by the state in formulation of its policies and in the process of governance. We have fundamental rights and DPSP. So we here in Directive Principles of State Policy mentioned in Part 4 of the Constitution from Article 36 to 51, we are trying to classify these Directive Principles of State Policy. No, in Constitution it has been classified. In Constitution, DPSP has not been classified. But for general understanding, we have classified. The experts of the Constitution, like MP Sharma, has classified Directive Principles of State Policy based on certain ideology. We have certain ideology right from, because the concept of socialism we have brought, we are following the concept of socialistic pattern of society. We have influenced by the Gandhian philosophy right from freedom struggle and post-independence, even in the drafting of our constitution also. We also inspired by various liberal approaches of Western countries. We also got inspiration from international agencies like United Nations, World Bank, IMF. So we have got inspired in framing our constitution from different sources of the world, and that is the reason we could generally categorize the Directive Principles of State Policy into 3 or 4 types. So just for a normal understanding, we have said whatever provisions are mentioned in DPSP can be categorized into socialistic pattern or socialistic principles. వీటినే సామ్యవాద సూత్రాలు అని అంటాము. We have Gandhian principles, Gandhian సూత్రాలు. We have liberal and intellectual principles, we also have international and Western principles. So on these grounds or on these ideology, we have generally classified the DPSP and its provisions for a common understanding. Otherwise, there is no categorization in the Constitution. We do not follow any ism, in fact. That is, we do not follow an ideology like socialist, a complete socialism we do not follow. We have a concept of mixed economy. Post 1991, we are sometimes moving away from the concept of socialism. Now, we have been following a market-based economy. We have many concepts which got inspired from the ideals of Mahatma Gandhi. So, we have also incorporated many provisions in Directive Principles of State Policy. For example, the Panchayat system, prohibition on intoxicating of drinks, or protecting the milching animals, and empowering the local people, that is cooperative societies. So all these principles we have placed in Gandhian principles, because Gandhian principles empowers or ensures that local government is made more powerful. As Gandhi said, India lives in villages. So the people in local area or villages have been empowered. They have been made participation in the governance of the country. We also have liberal and intellectual principles. So when we talk about participation of workers in the management, when we say a woman should give maternity relief, or when we say we have to improve the environment, so all these ideals, equal pay for equal work, so all these ideas now reflect the liberal thought of the Western societies. So not just confining to our society, our culture, we also added many such provisions which the developed countries or the Western countries are implementing. And that is also very good sign that we have been implementing these policies, and today India stands at a very respectable position. We have international and Western principles. We have, as borrowed this concept, DPSP and fundamental rights, we have inspired from International Covenant on Socio-Economic and Political Rights. We have seen many covenants, we have signed few agreements, we have inspired from United Nations. So all these things also we have inculcated in DPSP. So let's go with socialistic principles. These are the articles generally we study in socialistic principles. We have Article 38, 39, 41, 42, 43, 43A and 47. These are the articles generally we discuss in socialistic principles. Now we'll go into details and know what these articles say. So as we have already discussed Article 36, which defines the state, and Article 37, which talks about the applicability of Directive Principles of State Policy. For example, DPSPs are not enforceable. So these are the two articles. Going to Article 38, this article says that the state should strive for the establishment of welfaristic society. Prajala Shreyasu Kosam government part padali. So welfare is, here when we look the welfaristic society in a broader view, again we talk about all those things: narrowing the inequality, providing the upliftment or taking steps by the government for the upliftment of underprivileged section of the society, or giving special interest to those people who needs help from the government. or you can also say that the people who are rich, they need to be taxed, and that tax amount is spent on the development of the underdeveloped section of the people, or providing reservations in education, or giving public assistance. So all these concepts strengthen the concept of welfaristic state. Welfaristic state is different from police state, laissez-faire state. In laissez-faire state, the state will only come when there is a breakdown of law and order, or the state has responsibility only to regulate the government or governance. But in welfare state, the state will take upon itself the responsibility to provide the basic amenities to the people, right from shelter, food, education, health, and giving basic infrastructure like drinking water, electricity, road, transport. So all these basic amenities are provided by the state, might be at free of cost. We have seen many government schemes which provide these amenities to the people. So we have seen when there is a program of Garibi Hatao, there was a lot of free schemes like giving free home to the people who are homeless, distribution of land who are landless, or giving equal opportunity to the people to uplift their livelihood, or to give a basic standard of living. So that is the concept of welfare state, and it is the responsibility of the state to ensure that every section, every citizen should be brought inside the developmental net. No one should be made away, or no one should be excluded from the process of development. So the welfare of the people is the primary motto of socialistic pattern of society, and Article 38 emphasis on this concept of welfarism. When we say justice, this justice should be provided to the people. It is both socio-economic and political justice. In this topic especially, we concentrate more on socio-economic justice. So the society should be made in such a pattern that the individuals should be given opportunity for their development. That is, the state should strive for improvement of the citizen by providing them work. So that is where an individual will have economic independency. An individual is given an opportunity to work, and if that particular citizen is involved in the labor system, then definitely there is an improvement of its family that would lead to the growth of the society. Similarly, we have social justice. We have both individual and social. A community should be taken into consideration when the government prepares to frame a policy. So all sections of the society, children, women, old age, students, government employees, manufacturers, agrarian society, farmers, labor, so everyone should be given a focus, or everyone should be given an opportunity to make their life better, setting a better standard of life. So that is justice. To achieve such justice of socio-economic, we need to minimize the inequality. Until and unless there prevails inequality, we cannot say that we have achieved socio-economic justice. Political justice is just a justice where a person would participate in political system, but for that matter, socio-economic justice is more important for the development of their family, for the individual itself. So minimize inequality. Inequality should be reduced in all factors. it should be reduced in terms of income. The inequality should be reduced in terms of status. It should be reduced in all forms so that there prevails a sense of satisfaction among the citizens of the country. So Article 38 gives importance to welfaristic society, socio-economic political justice by reducing the concept of inequality, that is by minimizing the inequality. Article 39. This article is as important as earlier articles. This article talks about the basic things which an individual should be provided. So the state should ensure that every citizen is provided with adequate means of livelihood. Here, when we say adequate means of livelihood, it means the state should bring such policies which gives work to the citizen or which creates a good environment, the working conditions to the citizen. So adequate means of livelihood is important for economic justice. Why we have such a huge unemployment? We can say that the state has failed somewhere or its policies are not targeted to reduce unemployment. So for example, we have MG Narega, Mahatma Gandhi National Employment Guarantee Scheme. With that, the government has tried, the state has tried to give work to the people. With that, there is a continuity in the economic system. Where there is a consumption, there is a demand. Where there is a demand, there have to be a supply. And where there is supply and demand, there have to be production. So for this continuous or cycle of economic policy, the government should provide opportunity to the people to work. So we have mentioned this in our Directive Principles of State Policy. The state should ensure that it provides livelihood or work to the people. The state should ensure that the material resources of the country is not concentrated in the hands of few people. When we say we have socialistic pattern of society, the state policy should be formulated in such a way that the material resources are equally distributed for the good of community. So the wealth of the nation should not be in the hands of few. That creates lot of inequality. So when there is lot of inequality, obviously the nation would face many problems in terms of unbalanced development, sector-wise, region-wise, and in some times even community-wise also. So the ownership and control of material resources should be generally in the hands of the state, and state should ensure for equitable distribution of such material resources. We say the state should play a regulatory role in achieving the concept of equality. So the ownership, the main aim of socialism is the state should own the material resources, and the state should provide the opportunities for everyone to enjoy the resources. Here in this case, as we do not follow pure form of socialism, we follow mixed economy. So the ownership of material resources is also in some cases concentrated in the hands of few people. The state should ensure that the concentration of wealth should not be in the hands of few people, and only few people should not benefit from the process of development. The fruits of development should reach the last person, Antyodaya, that is, last person standing in the queue should also enjoy the fruits of development. So this is what we said, avoid concentration of wealth. You need to distribute the wealth. The other concept in Article 39 is which highlights or which strengthens the welfaristic approach of the state and socialistic pattern of the state or society. There is an equal pay for equal work. This is irrespective of the gender. Men and women should be given equal remuneration or equal pay for the same or similar nature of the work. So this is also we have mentioned in Directive Principles of State Policy. Following this, there are many law, many policies, legislations brought by the state giving equal importance to men and women at workplace. Probably women should be given more importance in taking the sensitivity or the gender of the female. So we have maternity relief that gives a paid relief or paid leave of some time, that is 12 weeks as of now. So they are given more importance, that is they need a special focus or special interest. Other thing is health of the workers. This we have provided in DPSP that if a community or the population who is into the labor net, if the state ensures their good health, obviously they would add for the development, they would add in the process of development. So it is the responsibility of the state to provide good living standards, that is provide good conditions at work, because health of the worker is important to have a production which matches the consumption. And also childhood and youth shall not be exploited. This is also a provision under Article 39. It is the responsibility of the state to draft certain policies which gives freedom for childhood, freedom for youth to express or to grow in whatever manner they wish to. So it is improving their overall development. The state should take responsibility. For example, the state should build such schools, vocational centers, health centers, sports and other activities where a youth and students are engaged. This is also a step towards curbing or towards prohibiting child labor, towards minimizing the crimes, towards a healthier development of the society, towards improvement of the sports and well-being of an individual. So this is also the responsibility of the state. When framing policies, all these provisions should be considered. So that is Article 39. When we say socialistic principles, here we are focusing on the welfaristic state. Article 40 is discussed in Gandhian principle. So we discuss Article 40 in Gandhian principle. Here we'll continue with Article 41. Article 41 says the state should secure or it should ensure that every citizen should be provided or given an opportunity to work. Every citizen should be given an opportunity to study, that is right to work, right to education, and we also have public assistance. Public assistance is the government should ensure or the state should ensure that certain section of the people, underprivileged section like old age people, disabled people, sick people, children's, youth, these sections, unemployed sections, unemployed people, all these sections of the society should be given priority. They should be given some assistance from the government. For example, when we talk about old age pensions, old age people may not go to work and earn. So, when they turn 60 or plus, the state should provide them with minimum pension so that they could live a dignified life. Similarly, disabled people should also get some pension to their assistance, to their livelihood. Unemployed youth should be also given a package or assistance, that is public assistance, in terms of loans or scholarships for the students. So many welfare schemes of the society, of the state, be it central government or state government, intends to give importance or for the upliftment of these sections. Many schemes are there, right from pension schemes, MSME schemes, banking schemes, insurance schemes, whatnot. So many schemes are there in public assistance. So Article 41 is mainly focusing on work, education and public assistance. Public assistance is a very big or broad terminology. We would see many schemes under the central government and state government which targets this section of the society, be it agrarian, be it labor class or employed in the manufacturing sector, or students or unemployed youth, etc. So public assistance is the responsibility of the state to provide some assistance, material assistance for the development of certain section of the people. Article 42 talks about securing justice for women especially, and giving good conditions at work. So we say that everyone should be given equal importance at the workplace. There shall not be any gender discrimination. So securing a humane condition of work, that is a good environment, good leisure period, good condition of work. So all these things the state should make sure that any organization, be it private or public, any organization where there is a work, the organization should ensure that just and humane conditions should be provided for the people working there. Especially the organization should have a policy where they should give special assistance to pregnant women or ladies in general. So that is Article 42, providing just and human conditions of work and maternity relief post pregnancy and pre-pregnancy also. That was Article 42. Now we discuss Article 43. Again, I remind, these are all the provisions in Directive Principles of State Policy which intends to establish a socialistic pattern of society concentrating on welfareism of the people, that is welfare of the society. these all provisions may not be enforceable in the court, but the state should contribute, or the state should take the responsibility to link all these, or these all provisions are followed in framing policies. Article 43, secure to all workers a living wage and decent standard of life. What is living wage? So, the state should provide with such conditions at work for good salary or good income and a decent standard of life. Every worker should be given a very good standard of working conditions. So, they should be given a minimum wage for their survival, for their livelihood, and that should not exploit a person. They should not made to work more, but standards are followed in employment and the wage remuneration should be at par with the work they do. And participation of workers in the management. This we have added by amending the constitution. As we follow a socialistic pattern of society, the participation of workers in the management brings a sense of a participative nature, that they also feel that the organization is for us and we are for the organization. There should prevail a employee-employer relation, and we can also say that they should have a participation, that is a profit sharing also. So participation of workers in the management gives a sense of participative nature, that is they work for the organization, not just for salary. There is a friendly relation which improves or which enhances the production of the organization. So participation of workers in the management, this concept we have added by Constitutional Amendment Act. So Article 47 says, it emphasizes that the state should provide good nutrition to the people so that the people live in a healthy life. So to raise the level of nutrition, as we discuss the concept of fair price shop, that is food distribution, the state has the responsibility to provide essentials for the poor and for the people who cannot afford. So by giving free distribution of food by ration, that is ration cards, we distribute, the state will distribute the essentials like rice, sugar, oil, anything for the people at subsidized rates. So it is the responsibility of the state that no one in the society faces the problem because of malnutrition or because of hunger. So nutrition, provision of essentials like food is also the responsibility of the state, because when we say the standard of the people or the living standard of the people should be improved, that is one thing, that is preventive. We can also say that the state should take such steps to provide good health for the people. So we have primary health centers at village level, we have district hospitals, we have government hospitals at state level. So all these hospitals which provide free health care to the patients or to the needy people. So under this Article 47, it is the responsibility of the state to provide nutrition and to improve public health. So all this we have to follow. All this the state government need to be followed in framing its policies. So we can say that Article 47 will guide the state when, if there is a health policy, so they should consider these things. The health policy should be in such a way that it is in reach to the underprivileged people or the people in need. ఈ విషయంలో అందుకే చాలా గవర్నమెంట్ హాస్పిటల్స్ ఉన్నాయి, మనము గవర్నమెంట్ స్కూల్స్ ఎస్టాబ్లిష్ చేస్తాము, ఫ్రీ ఫుడ్ ప్రొవైడ్ చేస్తాము. స్కూల్స్లో మిడ్ డే మీల్ ప్రొవైడ్ చేయడంలో కూడా ఈ ఆర్టికల్ని ఇన్స్పైర్ చేస్తుంది. ఈ ఆర్టికల్ ద్వారా మనము సర్వశిక్ష అభియాన్లో ఫ్రీ ఎడ్యుకేషన్ ప్రొవైడ్ చేస్తున్నాము, అక్కడ మిడ్ డే మీల్ కూడా ప్రొవైడ్ చేస్తున్నాము. మన తెలుగు రాష్ట్రంలో ఆరోగ్యశ్రీ అంటాము. సో అది కూడా ఒక టైప్ ఆఫ్ పబ్లిక్ అసిస్టెన్స్, గవర్నమెంట్ నుంచి పేదవారికి ఉపయోగపడే హెల్త్ స్కీమ్. అలానే రేషన్ షాప్స్ ద్వారా చాలా వరకు పేదవాళ్ళకి హూ ఆర్ బిలో పావర్టీ లైన్, దే విల్ బీ గివెన్ free subsidized food or the essentials at lower cost. All these things are taken into consideration when the state formulates policies. Fundamental duties. Just a reminder, we have already discussed fundamental rights, directive principles of state policy, importances of DPSP, their features, and what all the Supreme Court cases have heard or the judgment we got on those cases. Today again important topic, Trinity as we call, fundamental rights, directive principles and fundamental duties. One thing we need to remember is fundamental duties were not part of original constitution. In original constitution there was no mention regarding fundamental duties. Our founding fathers of the constitution or the framers of the constitution did not find it necessary to add fundamental duties in our constitution. We can also say that no democratical run country or no democracy, be it United States of America, Canada or other such countries, they too do not have fundamental duties in their constitution. Only Japan, which is also a democratic country, has inculcated these fundamental duties in their constitution. But many other ideological countries like China, Russia, those are communist countries, they have mentioned fundamental duties in their constitution. We are the only nation, a democratically run nation, which have made fundamental duties part of our constitution. So just to have a background of fundamental duties, we have added fundamental duties by 42nd Constitutional Amendment Act. It was during the time of emergency, that is in 1975 emergency has started and it continued till March 1977. So our Prime Minister Indira Gandhi at that time has thought it necessary to have fundamental duties mentioned in our constitution. Fundamental duties are not mentioned in original constitution. We have brought these fundamental duties by 42nd Constitutional Amendment Act. ఈ ప్రాథమిక విధులు అనేవి మన ఒరిజినల్ కాన్స్టిట్యూషన్లో ఎక్కడ మెన్షన్ చేయలేదు. మనకు అత్యవసర పరిస్థితుల్లో ఎమర్జెన్సీ విధించినప్పుడు 1975 నుంచి 1977 మధ్యలో చాలామంది లీడర్స్ని ఇల్లీగల్ డిటెన్షన్కి గురి చేశారు. సో మెనీ లీడర్స్ హ్యావ్ బీన్ డిటైన్డ్ అండ్ సెంట్ టు జైల్. దోస్ లీడర్స్ వేర్ ఆస్కింగ్ ఫర్ ద రైట్స్ అండ్ మెనీ ఫండమెంటల్ రైట్స్ హ్యావ్ బీన్ వైలేటెడ్. సో అలాంటి పరిస్థితిలో ఎక్కడైతే ప్రాథమిక హక్కుల కోసం అడుగుతున్నారో అంతే ద్వారా ప్రాథమిక విధులు కూడా నిర్వహించాలని గవర్నమెంట్ ఒక కమిషన్ ఏర్పాటు చేసింది. అదే సర్దార్ స్వరణ్ సింగ్ కమిటీ. సో సర్దార్ స్వరణ్ సింగ్ కమిటీ హ్యాస్ రికమెండెడ్ మెనీ థింగ్స్ విచ్ ఆర్ రిలేటెడ్ టు ఫండమెంటల్ డ్యూటీస్. సో ద మెయిన్ థింగ్ టు నో అబౌట్ ఫండమెంటల్ డ్యూటీస్ ఆర్ these fundamental duties have been added by 42nd Amendment Act. సో ఈ అమెండ్మెంట్ ద్వారా మనకి ఈ ఫండమెంటల్ డ్యూటీస్ని కాన్స్టిట్యూషన్లో యాడ్ చేయడం జరిగింది. అది ఒరిజినల్ కాన్స్టిట్యూషన్లో లేదు. వీటి కోసము మనం ఒక కొత్త పార్ట్ని తీసుకున్నాము. సో పార్ట్ 4A మనకి పార్ట్ 4 అంటే డైరెక్టివ్ ప్రిన్సిపల్స్ ఆఫ్ స్టేట్ పాలసీ. అదే పార్ట్లో ఒక కొత్త సెక్షన్ యాడ్ చేసాము, పార్ట్ 4A. దాన్ని ఫండమెంటల్ డ్యూటీస్కి మనము తీసుకున్నాము. సో పార్ట్ 4A రిప్రజెంట్స్ ఫండమెంటల్ డ్యూటీస్. ఇట్ ఈస్ ఓన్లీ మెన్షన్డ్ ఇన్ ఆర్టికల్ 51A. ఆర్టికల్ 51Aలో అన్ని ఫండమెంటల్ డ్యూటీస్ అనేది మెన్షన్ చేయబడింది. సో ఇట్ ఈస్ ఓన్లీ ఆర్టికల్ 51A which has 10 fundamental duties in original, and then in 2002, that is by 86th Constitutional Amendment Act, we have added one more fundamental duty. So the basic background behind fundamental duty is, as we know, there was an emergency period and many leaders have been jailed. So there was a demand regarding fundamental rights, violation of fundamental rights. So at that point, Indira Gandhi has decided to constitute a committee regarding fundamental duties. So Sardar Swaran Singh was a member of cabinet in the then government. So he has recommended these duties, and the recommendations have been accepted by the government, and fundamental duties were made part of part 4A. A new part has been created and we have mentioned fundamental duties in part 4A. So that was regarding when internal emergency was in operation. Sardar Swaran Singh committee was made, and this committee has recommended for inculcation of fundamental duties in our constitution. One point to remember, fundamental duties were not part of original constitution. By 42nd Amendment Act, we have brought this. So unlike directive principles or unlike fundamental rights, fundamental duties are not enforceable in the court. They are not justiciable. So we can say that even directive principles of state policy that is mentioned in part 4 of the Constitution, from article 36 to 51, DPSP are mentioned in part 4 of the Constitution, from article 36 to 51. Even DPSPs are not justiciable. They are not enforceable by the court. Only fundamental rights are enforceable by the court. So here when we say fundamental duties, they are also non-justiciable. So what all are there in fundamental duties? We need to understand first thing, why we need fundamental duties and why we call these as fundamental. వీటిని మనము ఫండమెంటల్ అని ఎందుకు అంటాము? Because these duties are mentioned in the constitution. ఇవి కాన్స్టిట్యూషన్లో మన రాజ్యాంగంలో పొందపరిచి ఉన్నాయి కాబట్టి రాజ్యాంగం అనేది మన ఫౌండేషన్ ఆఫ్ ద లా. Constitution is fundamental for our law. It is the source of power to all the executive bodies, legislative bodies or judicial bodies. So as we know, Constitution is fundamental and it is the source of power. Hence when we mentioned duties in the Constitution, we call it as fundamental duties. Should not confuse with the word that is fundamental rights. Fundamental rights are enforceable in the court. Fundamental duties are not enforceable. But there are many law which makes it a statutory. That is, few laws are there which makes these fundamental duties enforceable. Difference is, if anyone aggrieved person whose fundamental rights are violated, he or she can move the court. But in this fundamental duties, it is not the case. So fundamental duties are not directly enforceable. Courts do not issue writs regarding enforceability of fundamental duties. So originally we had 10 fundamental duties mentioned in Article 51A. From 51A, A, B, C, D, E, F, G, H, I, J. So these are the 10 fundamental duties. Now we will know what are these fundamental duties. Fundamental duties is how a person should behave, what are their responsibility. At one hand, when we ask for justice, at the same time, we should also know about our responsibilities. So, rights and responsibilities, that is fundamental rights and fundamental duties, are like two sides of the same coin. They both are important for individual development and for the development of the nation. So here in first, that is Article 51A, this is first point. To abide by the Constitution. To abide by the Constitution and respect its ideals and institutions. So it is the duty of every citizen. It is the duty of every citizen to work or to perform within the limits of the Constitution. So we know Constitution is the source of power. Constitution is sovereign authority. Constitution is highest law of the land. So everything is mentioned in the Constitution, be it legislative, executive or judiciary. All these branches should work according to the Constitution. No authority is higher than Constitution. Likewise, because fundamental duty says that every citizen should abide by the Constitution. No action or no work should be done which is against the Constitution. So to abide by the Constitution, because Constitution is the highest law of the land, supreme law of the land, and to respect its ideals and institutions. We have ideals in the Constitution, basically which are mentioned in preamble. Generally we say in preamble, India is a sovereign, socialist, secular, democratic republic country. It should provide justice, socio-economic, political justice to the people. There should be a sense of fraternity. So all these things what are mentioned in the preamble are ideals of the Constitution. So it is the responsibility or duty of any citizen to respect such ideals, because it is mentioned in the Constitution. And when we say to abide by the Constitution, no such act should be done by any citizen which goes against the spirit of the Constitution. So Constitution, రాజ్యాంగం అనేది మన సుప్రీం అథారిటీ, బేసిక్ లా ఆఫ్ ద ల్యాండ్. సో ఏ ఏజెన్సీ అయినా, లెజిస్లేటర్, జ్యుడిషియరీ, ఎగ్జిక్యూటివ్, ఏ ఏజెన్సీ అయినా, ఏ బ్రాంచ్ అయినా కాన్స్టిట్యూషన్ మన రాజ్యాంగాన్ని లోబడి పని చేయాలి. ఏ పని అయినా రాజ్యాంగానికి వ్యతిరేకం కానివ్వండి, లేదంటే రాజ్యాంగ స్ఫూర్తిని ఇన్సల్ట్ చేసినట్టు కానివ్వండి, అలాంటి వర్క్ చేయకూడదు. సో సిటిజన్ షుడ్ బి రెస్పాన్సిబుల్ టు నో వాట్ ఈస్ ద కాన్స్టిట్యూషన్ అండ్ దేర్ యాక్షన్స్ షుడ్ బి విత్ ఇన్ ద లిమిట్స్ ఆఫ్ ద కాన్స్టిట్యూషన్. మనకు రాజ్యాంగంలో చాలా ఇన్స్టిట్యూషన్స్ ఉంటాయి. We can say we have constitutional bodies, we have non-constitutional or statutory bodies. For example, Election Commission, CAG, Finance Commission, these are the constitutional bodies. So every citizen has duty, it is their duty to respect such institutions, such constitutional bodies. No one can be derogative or no one can act or talk against such institutions which generally degrades the constitution. And again, in this duty, we also say that every citizen shall respect national flag and national anthem. See, national flag and national anthem represents the nationalism, the patriotism of a citizen. So, when we have respect towards national flag or national anthem, we feel pride about our country. Until and unless we don't feel pride about country, we are disrespecting our freedom fighters, our constitution, our country, our motherland. So every citizen has a responsibility and they shall think as their duty to respect national anthem and national flag. There are many cases in the court also. The Supreme Court also in many judgments said that national anthem should be respected. We will do those cases at the end. So this is first duty, that is to abide by the Constitution, to respect the ideals mentioned in the Constitution, and also constitutional bodies, that is institutions, and to respect national flag, to respect national anthem. The second duty is to cherish and follow the noble ideals. Here we should know what are the noble ideals. We need to cherish and follow the noble ideals which had inspired our freedom fighters, that is, which has inspired our freedom fighters in national struggle for independence. So we know we have been ruled by British for many years, and our freedom fighters have few things or ideals, moral values that has inspired our freedom struggle. So for example, non-violence, Swaraj, these are the things which has inspired our freedom struggle. Why we need to cherish and follow? Because we know the greatness of such actions, such ideals. We have gained independence fighting a mighty empire by non-violence way. So we have to cherish the sacrifices of those freedom fighters, because of whom now we are free. We could enjoy the sovereignty, we could enjoy the freedom, we have all those fundamental rights. So that is our duty, to cherish and to follow the ideals, noble ideals which has inspired our freedom movement and obviously freedom fighters. The next duty is to uphold and protect sovereignty, unity and integrity of the India. So we have a very diverse culture. We have very heterogeneous society. We have multi-religion, multi-caste place. We have very diverse geographical entity. So obviously there are different kind of people, and because we have a unity in diversity, we need to uphold that values. So it is our duty, it is the duty of every common citizen to uphold and protect sovereignty, unity and integrity of India. మన సార్వభౌమత్వాన్ని, మన యూనిటీని మనము ప్రొటెక్ట్ చేయాలి. అది ప్రతి పౌరుడి యొక్క విధి. అది దట్ ఈస్ దేర్ రెస్పాన్సిబిలిటీ. ఎందుకంటే మన ఈ కంట్రీలో మనం చూస్తాము మతాల వారిగా, కులాల వారిగా చాలా డైవర్స్ ఉంది మన కంట్రీ. సో చాలా డిఫరెంట్ సెక్షన్ ఆఫ్ పీపుల్స్ ఉంటారు. వాళ్ళని అందరినీ ఒక తాటి మీద తీసుకురావడము, వాళ్ళ సెంటిమెంట్స్ని మనం గౌరవించడము, ఇది ఇంపార్టెంట్. అది ప్రతి పౌరుడి యొక్క విధి, అది డ్యూటీ. వాళ్ళు వేరే మతంకి చెందిన వాళ్ళని అదే సెంటిమెంట్స్ని గౌరవించాలి. సో దేర్ వీ నీడ్ టు ఫాలో certain ideals, because we say we have to follow that Sanatana Dharma policy. So to uphold the integrity of India, we need to respect the sentiments of other religion people. We have to bring a sense of brotherhood. That is, we have to bring them together. So that is where it is the duty of every citizen to respect the sentiments, because we have such a diverse culture. We have very diverse traditions. So all these things can be brought together when we have a sense of unity among the people. So that is why we say every citizen should uphold and protect the sovereignty, unity and integrity of India. So next fundamental duty is to defend the country and render national service. Render national service, that is to defend the country and render national service whenever the government asks a citizen to do so. So this is very important fundamental duty. Any citizen should be ready at all times to render their services whenever the government needs us. సో మనకు ఎమర్జెన్సీ సిచ్యువేషన్స్లో ఎక్కడైనా మన కంట్రీ వార్లో ఉంటే స్టేట్ అంటే గవర్నమెంట్ మన సర్వీసెస్ ఉపయోగించుకోవడానికి ఒక నివేదిక అంటే ఒక కాల్ చేయొచ్చు. సో వీ హ్యావ్ టు బి రెడీ. అగైన్ ఇట్స్ నాట్ కంపల్షన్, but as a responsible citizen, it is our duty to render our services when the state needs us. It is not like we just enjoy our fundamental rights but forget our duties. You take many examples, like when there is a natural calamity like floods, tsunami, earthquakes. Voluntarily, citizen will go forward and take the responsibility of rescuing people, taking them to hospitals, giving them first aid. So, as a responsible citizen of the country, it is the duty of the citizen to help others. The government also may at some times ask us to give their voluntary service, give our voluntary service. So, it is the duty of every citizen to defend the country. When a country is at war, a citizen should join the forces. They have to render the national service. When called upon to do so, whenever there is a necessity, whenever there is a need, the state will appeal to the citizens to participate in national defense. This is a very important duty every citizen should abide to, because it is not that in our India rendering service is compulsory, service in military is compulsory. As we have seen in many countries, there is a compulsory service in army. Every citizen at some point of time should give their service in the national army mandatorily, but we do not have such obligation. But in certain circumstances, when country needs us, we have to be ready to give our service and defend the nation, because nothing is above the nation. Nothing is above our motherland. So we need to be ready for ultimate sacrifice also. This promotes the concept of patriotism, nationalism, integrity of India. So this has been mentioned in fundamental duties. Every citizen should abide, should move forward for voluntary contribution of the services. Next duty is to promote harmony, and spirit of common brotherhood. This word is important, spirit of common brotherhood. So next duty is to promote harmony and spirit of common brotherhood. This is a very important word, common brotherhood. We also call it as fraternity, భ్రాతృత్వం. ఇప్పుడు వరకు మన కల్చర్ అనేది చాలా డైవర్స్ కల్చర్, చాలా రకాలుగా అన్ని మతాలు అన్ని కులాల వారు ఒక దగ్గర ఉంటారు. సో అలాంటి దగ్గర ఒక శాంతియుతమైన వాతావరణము ఉంచుకోవడానికి మన ప్రతి సిటిజన్ ప్రతి పౌరుడికి అది ఒక డ్యూటీ. సో యాజ్ వి సే వీ హ్యావ్ మల్టీ రిలీజియస్, multilinguistic and regional wise also we are very diverse, and in this culture as we have such a vast diversity we can have a sense of brotherhood, and to prevail that sense of brotherhood, to prevail the sense of fraternity, it is the duty of every citizen to promote harmony, to promote peace and spirit of common brotherhood. So every citizen should take upon themselves the responsibility to promote peace and harmony and to have a coexistence which transcends, that is, which transcends religion, region, culture, caste and such things. So మన దేశంలో ఇంత వాస్ట్ డైవర్సిటీ దగ్గర ప్రతి చాలా రకాల కులము మతము ఉంటుంది కాబట్టి అక్కడ మనం పీస్ని ప్రివేల్ చేయాలి. సో వీ హ్యావ్ డైవర్సిటీస్ రిగార్డింగ్ రీజన్, రిలీజన్, లాంగ్వేజ్, సెక్షన్స్ అండ్ ఆల్. సో టు హ్యావ్ అ సెన్స్ ఆఫ్ యూనిటీ, టు హ్యావ్ అ సెన్స్ ఆఫ్ ఇంటిగ్రిటీ, every citizen should follow their own spirit and respect the sentiments of other religious people. There should be a sense of brotherhood and fraternity. There should be a sense of tolerance, because intolerant could lead to clashes. It might be communal clash, class clashes, riots, such violence activities. So the tolerance is the basic word in promoting harmony. We should spread peace and promote harmony. That is one part of the duty. Second is to renounce practices derogatory to the dignity of women. In our culture, we respect women. We treat them equivalent to goddess. So no such actions is tolerated which is against the morality or dignity of the women. ఒక నైతిక విలువ కల ఏదైనా కాపాడుకోవాలి. సో ఈ డెరోగేటరీ అనేది, ఈ యాక్షన్స్ అనేది మనము వర్జించాలి. సో వీ నీడ్ టు డినౌన్స్ such activities which are against the values, moral values, or which is derogatory to the women and their dignity. So we have seen there are many law which punishes a person whose actions are derogatory to the woman. For example, we have laws against exploitation at the workplace. We have domestic violence laws. We also punish eve teasing or such actions. There are anti-dowry acts. So there are many acts which has a stringent punishment if any citizen violates those things. So it is the duty of every citizen to respect women, be it cinema, media, broadcasting, magazines or anything. It should not be against, or the content should not be derogatory to the dignity of the women. So it is the duty of every citizen to abide by such moral values. This is very important duty, and we have a very stringent law and punishable, which leads to setting in jail or having a huge fines. Next duty is to value and preserve the rich heritage of the country's composite culture. As we have already discussed, we have a composite culture, that is, India doesn't have a single culture, as we are multi-religious, multi-linguistic, such a vast geographical entity. The culture is also vast. We have vast culture, right from north to south, west to east. So such a composite culture is a rich heritage for any country. And India, as we say, has a very historic background, and we promote all religions equally. We respect all religions and all cultures equally. So it is the duty of every citizen to value and preserve. We have to value. That is, we have to respect others' culture. It may be in the form of art, dance, music, script, literature, cinema, dress, whatever it is. It is the duty of the citizen to respect others' culture, others' value. So here every citizen shall do this. They have the duty to preserve the rich heritage of country's composite culture, because this, as we say, composite culture, having such many cultures in our land, is a rich heritage. Next duty, to protect and improve natural environment. So generally when we talk about fundamental rights, if any action of the state violates your fundamental rights, for example, right to life and liberty, in this we have discussed that right to life is not just living in a vegetative condition. We should live with dignity. So it is the responsibility of the state to provide every citizen with a livable condition. When I say livable condition, it might be safe drinking water, unpolluted air, that is safe air, good nutritious food, good infrastructure in terms of electricity, roads, connectivity, whatever, schools, healthcare. So all these things the state will take upon itself the responsibility to provide to the citizens, and that is what we have mentioned in fundamental rights too. If any action of the state violates your fundamental rights, that is the right to life, the right to livelihood, then that particular citizen will move court, and court will invalidate such action of the state. So here we are very much anxious about our rights, but what about our duty? We are expecting a lot from the state, but what you are contributing towards nation? So here when we say to protect and improve natural environment, so as a citizen, as a responsible citizen, it is our duty to protect our surroundings, to protect and preserve rich heritage, that is natural environment, to protect our trees, to protect and preserve our lakes, rivers, water bodies, forest, all such things which are naturally available. We cannot just destroy the pleasant atmosphere around us. So making noise, polluting air. These are all things which a responsible citizen should not do. A citizen should take care about our natural resources, our environment. So just we cannot say that it's not my duty, state will take care of it. No, when you fight for your right, it is also your duty to protect your surroundings, to protect your natural resources. So here in fundamental duties we say it is our duty to protect and improve the natural environment, which includes forest, lakes, rivers, wildlife. So we have many programs where the state involves the citizen. The state makes sure that every citizen should be participated in such programs like afforestation, planting trees, cleaning rivers, or cleaning beaches. So these are the things where every citizen shall go forward and take the responsibility upon themselves to have a clean and safe environment. We have many programs. For example, in Telangana government, Harita Haram is there. So Harita Haramlo మనం చెట్లు నాటుతాము. అది ప్రతి పౌరుడు వాళ్ళ బాధ్యత అనుకొని ఆ చెట్లు నాటాలి. నాటడంతోనే సరిపోకుండా వాటిని మనము సంరక్షించుకోవాలి. So these are the things where the state will expect from a responsible citizen. After all, it is our nation, it is our society, it is our environment. To give the best to our coming generations, we need to have a sustainable development. So we should not exploit the natural resources what we have today. We need not to destroy the pleasant atmosphere. So air pollution, water pollution, sound pollution, all these things should be avoided. We generally see no honking at traffic signals. People honk wildly. These things are not good. People, for example, they just pollute the rivers, pollute the lakes. That will definitely cause some effect on other side also. So for that matter, it is our responsibility to protect our environment. When we say wildlife, wildlife is also part of the ecology, and to ensure that there is a balance between this ecology, wildlife have to be protected. They are rich heritage. And that is the reason we have many government policies like establishing or creating national parks, wildlife sanctuaries, tiger reserves, bird sanctuaries, zoological parks, we call it as a zoo parks. So both in situ and ex situ preservation and protection of wildlife. We have many programs such as social forestry, afforestation programs, community forestry, cleaning of rivers periodically, as we have Ganga cleaning program. It's a huge program where river Ganga is being cleaned. So it is the duty of every citizen at least to protect those natural resources and environment, and to have a compassion for living creatures. Here we need to show some compassion towards living creatures, because even living creatures are part of the environment. They are in coexistence with us since ages. So we need to show some compassion towards them. So street dogs you take, or when you are in some trip, you would see lot of monkeys and all. You feed them. So we have to show some compassion, some sort of empathy towards living creatures also. So having a responsibility towards our environment obviously promotes the sense of a patriotism or a sense of satisfaction that we are a responsible citizen and we are abiding by these fundamental duties. Next duty is to develop scientific temper. Why we have added this in our fundamental duties? Do not have a scientific temper? Yes, we are lacking in scientific temper. Many of the citizens just believe what they are told. So there should be a sense of inquiry, there should be anxiety to know the things, there should be a thought process based on rationality. ఏది చెప్పేసినా గుడ్డిగా నమ్మడం కాదు, దాని వెనుక ఏమి అర్థం ఉందో అది తెలుసుకోవాలి. అది ఒక సైంటిఫిక్ టెంపర్తో వస్తుంది. మనకి తెలవాలి, మూఢనమ్మకాల నుంచి బయటికి రావాలి. సో ప్రతి పౌరుడు ఆలోచించాలి, ఒక మాట వెనుక ఉద్దేశం ఏముందో ఆలోచించాలి. సో టు డెవలప్ సైంటిఫిక్ టెంపర్ we need to have a open mindedness, we need to have a inquiry sort of personality. తెలుసుకోవాలి, క్వశ్చన్ చేయాలి, ప్రశ్నించే తత్వం ఉండాలి. So it is also mentioned in fundamental duties. So how important is this? If you don't ask, if you just believe anything blindly, then you are not thinking on rational process. So to develop scientific temper, humanism and the spirit of inquiry, ప్రశ్నించి తెలుసుకునే ఒక తత్వం ఉండాలి ప్రతి పౌరుడికి. ఏది గుడ్డిగా నమ్మకూడదు. సో we should have a spirit of inquiry, a humanism and a attitude to bring reform. ఏదైనా మార్పు కోసం ప్రయత్నించాలి, మంచిగా మార్పు కోసం ప్రయత్నించాలి. ఉన్న సిస్టమ్ని ఇలానే కంటిన్యూ చేద్దామని కాదు. వెన్ వీ హ్యావ్ దట్ స్పిరిట్ ఆఫ్ ఎంక్వైరీ, we would definitely question the existence of such system. Further better, we need to bring some changes. Any entity should be dynamic, should not be static. So in the process of this dynamism, every citizen and their spirit, they have to take the responsibility to question the things, to know about the things, to work for the betterment of such things. So that is what scientific temper is. If we have a scientific temper, we would definitely match with the Western countries in everything like industrialization, mechanization, spaceships and all. So this is important. Next duty is to safeguard public property and abjure violence. Generally we see if there is any clash or strike or demonstration, general mob or people who have gathered there destroy public property. So generally government property is public property. When we destroy RTC buses or government buses, government property, then we would be causing ourself harm because government property is our property. So we need to have in mind, we need to keep this in mind that citizen, and it is the duty of those responsible citizen to protect public property. Generally, public property will be destroyed when there is a violence, there is a breakdown of law and order. So we need to abjure violence. Violence should not be the resort to solve any problems. There are many alternate ways. In the beginning also we have said that we need to follow and cherish the ideals which were followed by our freedom fighters, which has inspired our struggle for independence. So violence is not a solution, and we should also follow that public property shall not be destroyed because it is the government property. We have paid taxes for that. So we need to assume that public property is protected by every citizen. Okay, next duty under fundamental rights is to strive towards excellence. Whatever work you do, in whatever profession you are, in whatever sector you are, be it primary sector, secondary sector, tertiary sector, white collar job, blue collar job, permanent employee, temporary employee, whatever you do, any profession, irrespective of the nature of the work, you should excel in that work. So there shall be a discipline followed, there shall be a perfectionism followed to excel in one's work. So no work is inferior. You need to worship your work. That is why we say work is worship. So you have to strive hard towards getting this excellence. When you excel in your work, obviously you add to the development of the nation. Your every work is contributing towards nation's growth. So in all spheres of individual and collective activity, when you are in an organization, individually we need to give our efforts, and so collectively also we will grow. So both individual and collective efforts adds to the growth of that particular organization. In turn, it leads to the development of the society, development of the nation. So showing excellence in work, whatever you do, this will raise nation. The nation will raise constantly to higher levels. Even individually, if some citizen shows excellence in the work, they will achieve. So it is the duty of every citizen in the process of national development that every work individually and collectively should be excel. So we have to strive towards excellence in national development constantly. Very important. This duty inspires every citizen to work hard, to keep in mind that hard work would definitely adds to the growth of individual, their family, society and nation at large. Moving on to next fundamental duty, that is to provide opportunities. This thing we have added by 86th Constitutional Amendment Act. This was not part of the original fundamental duties which were inserted by 42nd Constitutional Amendment Act. This to provide opportunities for education to their children between the age of 6 and 14 years. See, this actually mentioned in Directive Principles of State Policy in Article 45. Then we have moved this to Article 21A as fundamental right. It is compulsory that children between 6 to 14 years of age should be given free and compulsory education. Now, why we have this in our fundamental duty? Here, when we say 21A, it is the fundamental right of the children. The state shall provide them free and compulsory education between the age of 6 to 14 years of age. But here in duty, the parent should provide such opportunities to their children so that they could go to school or they could study. So such pleasant environment are provided by the children, by the parents to the children. So the children should not be forced to do work. So this is where we say 21A, this is in fundamental right. We know the example, right to education. So this is added in our fundamental duties by 86th Amendment Act, which has also added Article 21A under fundamental rights. So these are the 11 fundamental duties mentioned in Part 4A of the Constitution under Article 51A. Presently, we have 11 fundamental duties. Originally, we had 10 only. This one we have added recently by 86th Amendment Act. So now we see what are the features of this fundamental duties. What are the salient features? What are the characteristics of these fundamental duties? So we say in all these 11 fundamental duties, we generally see there are two types of duties. One is moral and one is civic duties. Moral is where we have an inner feeling, morality or ethics. So this we have got from our culture. We have a very deep culture in India, and we have many religious scriptures, like you take Bhagavad Gita, Ramayana, Quran, Bible. So all these religious scriptures give us certain things, certain spiritual things which we generally follow in our lives. So even in fundamental duties, when we say you need to respect others' culture, you need to follow certain ideals. So all these things are morality which we generally have in any religion. We have civic duties, that is what you are doing towards your community, towards your fellow men. When you are in a group or in a society, in a community, you could not behave as you like. You have some civic responsibility. So in fundamental duties, we have both moral duties and civic duties. నైతిక మరియు పౌర విధులు. నైతికత అంటే మొరాలిటీ, అది మనకు చాలా స్క్రిప్చర్స్లో, మన రిలీజియస్ స్క్రిప్చర్స్లో మెన్షన్ చేయబడి ఉంటుంది. మనము ఎలా ఉండాలి? ఫర్ ఎగ్జాంపుల్, పెద్దవాళ్ళని, ఉపాధ్యాయులని గౌరవించడం అది మన ధర్మం, మన సంస్కృతి. అది ఎక్కడా మనము రాసుకోలేదు. సో వన్యప్రాణుల వైపు మనము ఒక ప్యాషనేట్గా ఉండాలి, వాళ్ళని హింసించకూడదు. ఒక స్త్రీని ఎంత గౌరవం ఇవ్వాలి, సో అది మన స్క్రిప్చర్స్లో మెన్షన్ చేసి ఉంది. అది మనము ఫాలో అవుతాము. అది మన మొరాలిటీకి, మన ఎథిక్స్కి తెలిసినవి. సో అలాంటి కూడా కొన్ని విధులు ఉన్నాయి. సమాజంలో, ఒక సొసైటీలో ఎలా ఉండాలి, 10 మందిలో ఉన్నప్పుడు మనల్ని ఎలా బిహేవ్ చేసుకోవాలి అనేది కూడా ఫండమెంటల్ డ్యూటీస్లో, ప్రాథమిక విధుల్లో మెన్షన్ చేయబడి ఉంది. సో వీ హ్యావ్ బోత్ మోరల్ అండ్ civic duties, and there are many duties which refers to the values. విలువల పైన మాట్లాడుతుంది. సో హ్యూమన్ వాల్యూస్, we should have humanism, we should mold in such a way that we respect others sentiments. సో ఇలాంటివి కొన్ని విలువల గురించి కూడా మనం మాట్లాడడం జరిగింది. ట్రెడిషన్స్, మన సాంప్రదాయాలు ఎలా ఉంటాయి, సో విలువలు మరియు సాంప్రదాయాలను సూచిస్తుంది. సో దేర్ ఆర్ మెనీ ప్రొవిజన్స్ అండర్ ఫండమెంటల్ డ్యూటీస్ విచ్ రిఫ్లెక్ట్స్ అవర్ వాల్యూస్, అవర్ ట్రెడిషన్స్, అవర్ ఫెయిత్, అవర్ కల్చర్. సో ఇట్ ఈస్ నాట్ దట్ సంథింగ్ ఈజ్ వెరీ న్యూ టు అస్, something which are superimposed on the citizen. Generally we do follow these things. So when we criticize fundamental duties, generally there is a word. Indians are in general abide the constitution, or they do not go against the constitution. Generally they abide the rules. then why do we need fundamental rights or fundamental duties mentioned in the Constitution? So that is the deep culture what we have. But there is also necessity when the Constitution provides us with fundamental rights. It is also mentioned that some duties need to be as a reminder, there should be some duties which are expected by a common citizen. So when we say features of fundamental duties, we have moral and civic duties in all those 11 fundamental duties. These duties refers to values and traditions. And one more important thing is fundamental duties are applicable only to citizens of the country. So fundamental duties are applicable to only citizens. ఇక్కడ ఉన్న పౌరులకు మాత్రమే ఇవి వర్తిస్తాయి. So as similar to directive principles of state policy, even fundamental duties are not enforceable in the court. When I say non-justiciable, it is court cannot issue writ for enforcement of fundamental duties. వీటికి న్యాయ సంరక్షణ ఉండదు. ఇవి ఖచ్చితంగా ఎన్ఫోర్స్ అవ్వాలి అని కోర్ట్ చెప్పలేదు. ఎప్పుడైనా ఫండమెంటల్ డ్యూటీస్ కానీ ఎన్ఫోర్స్ చేయలేము. సో వీ కెనాట్ మూవ్ ద కోర్ట్ అండ్ కోర్ట్ కెనాట్ ఇష్యూ రిట్స్ ఫర్ ద ఎన్ఫోర్సబిలిటీ ఆఫ్ fundamental rights. As we seen in fundamental rights, the court will issue writs. Here there is not such thing. So fundamental duties are non-justiciable. They cannot be enforced by the court. But we cannot say that they do not have force in the law of the land. Yes, there are many legislations which backs the enforceability of fundamental duties, as we have with suitable legislations. For example, any action of a citizen which is a threat to sovereignty, unity and integrity of the nation, then there are many laws. For example, we have unlawful action prevention. So by UAPA, we have sedation law, we have preventive detention law. Those actions which are against the sovereignty, unity or integrity of the state has certain laws mentioned in things like Indian Penal Code, we have CRPC, Criminal Procedure Code, we have CPC, Civil Procedure Code. So all these laws will punish such person. So we cannot just say that fundamental duties are not enforceable. Though the court cannot issue writ, but by several legislations of the parliament, we enforce these fundamental duties if any action of the citizen goes against the constitution. So these are enforced by suitable legislations. We have, for example, Domestic Violence Act. If any action is against the dignity of the woman or derogatory to the woman, such persons are punished. We have Anti-Dowry Act, we have Anti-Domestic Violence Act, for example, we have Nirbhaya Act. So many acts are there, many legislations are there which enforce these fundamental duties. The criticism. Here we have done the big background or the basics of fundamental duties. We have done all those 11 fundamental duties mentioned in Part 4A under Article 51A. We have discussed features, that is characteristic features of fundamental duties. Now we move on with criticism of fundamental duties. See, when we say criticism, you should know what are the defects in fundamental duties. We are not criticizing fundamental duties like we don't need fundamental duties or fundamental duties are not needed. No, we have fundamental duties, but there are some loopholes there. That is what the thinkers or the experts of constitution, the analysis who make analysis, they give certain points on the basis of which we criticize the fundamental duties. Here, when we criticize the fundamental duties, we say that fundamental duties are not exhaustive. See, we have mentioned only 11 fundamental duties in our constitution. But is this enough? Do we have only 11 duties to follow? We may have many such things, but we could inculcate or we could insert only limited duties. Not every single action is expected from any citizen. So, when we criticize fundamental duties, we say that they are not exhaustive. అంటే అది మొత్తం కాంప్రహెన్సివ్ కాదు. అన్ని డ్యూటీస్ ఎవరైతే ఒక రెస్పాన్సిబుల్ పౌరుడు చేయవలసిందో అలాంటి అన్నిటినీ మనం రాసుకోలేము. మనకి 11 ఫండమెంటల్ డ్యూటీస్ మాత్రమే ఉన్నాయి. ఇక్కడ క్రిటిక్స్ ఏంటంటే ఈ 11 ఫండమెంటల్ డ్యూటీస్ అనేది కాంప్రహెన్సివ్ కాదు. చాలా డ్యూటీస్ని మనం వదిలేసాము, మనం కాన్స్టిట్యూషన్లో రాసుకోలేదు. సో ఆన్ దిస్ బేసిస్ వీ కెన్ సే దట్ ఇది సమగ్రమైనది కాదు, ఇట్ ఈస్ నాట్ కాంప్రహెన్సివ్. సో వీ ఇన్ ఫ్యూచర్ మే ఆల్సో యాడ్ few many duties depending upon the requirement. But as of now, we have 11 duties mentioned in our constitution. We criticize fundamental duties on one more thing, that ambiguity. Ambiguity ante there we have no clarity of the words. When there is a word like value or composite culture, these words cannot be defined. We do not define these words. So these words cannot be codified. So here definitely a common man or court itself will get confused. So వీటికి ఒక నిర్ణీత అర్థాలు లేవు. There is no clear meaning for such words. When we say value, when say ideals, when we say spirit, I mean these words are not clearly defined. So there may arise a sense of ambiguity, that is ambiguous, when there is any conflict between fundamental duties and fundamental rights, or between fundamental duties themselves. So that is where we criticize fundamental duties. We also say that moral precepts, the things of morality, the things like dignity, these things cannot be codified. We cannot value them. We cannot write them at one place. So these are the things which are to be felt. These are inner thought of any person. So these things cannot be codified or defined. So that is where we criticize fundamental duties. So these are superfluous. Fundamental duties are superfluous. That is, when we say fundamental duties are mentioned in the constitution, what is the constitution? Constitution is the highest supreme law of the land, and we say constitution is the people. People have written the constitution. It is by ourselves. At one hand we say constitution is sovereign, that is people has given themselves the constitution, and on other thing the same constitution reminds the same people of their duties. So there is a big confusion here. When we have written our own constitution and the constitution is for ourselves, then how could some same constitution will remind us for following some duties? That is what the critic says. It says that the fundamental duties are superfluous. ప్రజలచే సార్వభౌములు అది గ్రహించిన రాజ్యాంగం వారి విధులను నిర్దేశించడము సమంజసం కాదు. The same constitution which the people have given themselves are saying that you should also follow certain duties. That is where we call it as superfluous. Its value is reduced by adding in part 4. See, when we give such a important two fundamental duties, they act as reminders. These fundamental duties act as reminders for the citizen to perform certain duties or to take upon themselves certain responsibilities which is good for the nation. So, if we say that they are such important things, so they need to be part of fundamental rights. But here we have added to part 4, which are directive principles of state policy. Critics also say that there should be a separate part for fundamental duties. Why only one article, that is 51A? So critics says that we have reduced the significance of fundamental duties by inserting them, by amending the article 51, adding 51A and adding A to the part 4. So that is also one of the critics, where they assume that the significance of fundamental duties has been decreased. So that was the critics of fundamental duties. Now we see what are the significance of fundamental duties, how they add to the life of a citizen, how they add to the development of the nation. So, importance of fundamental duties, very important thing, it serves as a reminder. Each and every time fundamental duties serve as a reminder the what a common citizen should act, how should he behave, what are their fundamental duties to be followed, what is their responsibility. Now every time we see when there is a national flag, we need to respect national flag. When we hear national anthem, we need to stand up. So these are the reminders for a citizen to know their responsibilities, to protect environment, to cherish the ideals, to respect women. These are the things what we have mentioned in fundamental duties, and these act as a reminder to any citizen. So very politely, we cannot say that fundamental duties just are reminders. They are warning also. If you are not performing your duty, which is mentioned in the Constitution, or your actions are against the Constitution, then obviously there are certain laws which punish you. So we do have certain legislations which punishes certain acts which are against the Constitution. So we cannot politely say that fundamental duties are just reminders. They are warning also, warning against anti-national activities. So warning against anti-social activities. You cannot just assemble and talk something about our country which is not in the interest of the people. You cannot derogate any institutions. You cannot have a word. You cannot contempt the court process. You cannot have a word against the legislative process. So having a national activity is a punishable act. We have sedition acts which punishes a person who talks or whose action is against the nation. So fundamental duties are also warning against such citizens. When we say every citizen should cherish and follow certain ideals, every citizen should have a responsibility to protect the sovereignty, integrity and unity of the nation. If any action disturbs such integrity or is a threat to sovereignty of the nation, then these acts, there are certain acts which will punish such person. So they are not mild reminders, they are a stringent warning also. Fundamental rights are a source of inspiration. We have seen all these fundamental duties are source of inspiration. So many things we would generally get inspiration from these fundamental rights. When we say we need to protect our environment, we need to protect forest, lakes, wildlife. So we are getting some inspiration from fundamental duties. It also helps the court in minimizing the confusion. That is, whenever we feel some ambiguity, court will take help of fundamental duties, the provisions mentioned under fundamental duties. So if there is any problem with these, then there are certain laws. If any citizen is not abiding with the provisions mentioned in fundamental duties, there are certain laws which impose penalty for not abiding or not being responsible or not following these duties. So this is the significance. We have a Verma committee. After Sardar Swaran Singh committee, Verma committee was appointed to observe the existence or working of fundamental duties. So Verma committee has observed many legislations which support fundamental duties or which have certain legislations which will punish the actions which are against the fundamental duties. So prevention of insults of national honor, it could be insulting national flag or national anthem. We have this law. Under this, the citizen will be punished if that particular citizen dishonors national anthem or national flag. We have protection of Civil Rights Act 1955. So when we say we need to respect others' sentiments, others' religions, we need to protect our composite culture. If any citizen fails to do that, they would be punished under this act. When we say Unlawful Activities Act, if any action of a citizen is against the sovereignty or integrity of the nation, if that particular action incites to offense, then such person is punished under this act. That is the reason we say that fundamental duties are also enforceable, but by certain legislations. They may not have the enforceability, and we say they are non-justiciable. Court cannot issue writs, but we have several legislations which protects or which punishes such citizen who do not abide by these provisions mentioned in fundamental duties. So we have Representation of People Act. This is regarding elections. Representation of People Act. You cannot disrespect institutions mentioned in the Constitution. Wildlife Protection Act, where you should protect and preserve our national heritage, be it showing compassion towards wildlife, towards environment. So we have Wildlife Protection Act. Very stringent punishments are there in this act. It will reduce poaching. That is, if any person poaches wildlife or kills any wildlife or endangered species, such persons are punished. We have Forest Conservation Act. So these are all few legislations which gives teeth to the legislature or to the enforcement agencies to make the citizen deterrent when they think of not following certain duties. When you just jump a signal, red signal, or if you pollute your surroundings, then also there are certain acts which punishes you. So we need to be very responsible when we are in the society, and it is our duty to maintain such dignity when we are in a society. We personally should be very responsible, and we also need to make aware of these fundamental duties to other people also. So what are the other recommendations mentioned? Though we do not added all these things in fundamental duties in Article 51A, but we could have these recommendations also. See, January 3rd, should be celebrated as Fundamental Duties Day, because the fundamental duties have came into power from this day. January 3rd should be celebrated as Fundamental Duties Day every year. ప్రతి సంవత్సరము జనవరి 3 అనేది ప్రాథమిక హక్కు విధుల దినోత్సవం లాగా పాటించాలి. In every educational policy or any curriculum, any syllabus of the university, there should be a mention of fundamental duties. Fundamental duties should be added in the syllabus of schools, universities, colleges, so that the people try to understand and know what fundamental duties are. From their schooling age, they should take the responsibility as a responsible citizen. They need to know what are the duties when we are fighting for our rights. At the same time, we need also be having certain duties towards our community, towards our country. So in every curriculum, fundamental duties have to be included. అన్ని విద్యా ప్రణాళికలో ప్రాథమిక విధులను పాఠ్యాంశంగా చేర్చాలి. సో ఇట్ షుడ్ బి ఇన్క్లూడెడ్ ఇన్ ద కరిక్యులం ఆర్ సిలబస్. So every time we are talking about fundamental duties, but many people, as we have a lot of illiteracy in our country, many people do not know what fundamental rights are, what DPSP are, what fundamental duties are. So it is the responsibility of state and also individually for community to promote the sense of campaign. Like we have to bring awareness among the citizens. We have to make them know what fundamental duties are, what a citizen should do towards the nation. When they know about their rights, they should also aware of their duties. So here awareness campaigns should be promoted and publicity should be made. As whenever we have elections, the election commission will spend lot of money to create awareness, to make people know the importance of the vote. At the same time, all bodies, autonomous bodies should come together to make awareness and publicity by all media, be it print media, electronic media, social media, whatever it is. The people should make aware of their duties. That is only when we could say that people are responsible, because many of them do not know what their duties are. Then we should set a autonomous body, an ombudsman body, which looks into the matter of fundamental duties exclusively. So there should be an ombudsman, like what generally we have, like Lokpal, Lokayukta. Similarly, we should have an agency which is independent from the legislature and should focus on the implementation of fundamental duties or making aware of fundamental duties to all the citizens. So again, in the process of promoting or propagating the fundamental duties in any public places, we should have the charter of fundamental duties. For example, in metro stations, bus stations, airports, schools and colleges, government offices, mandal offices, we should have a charter of fundamental duties so that the citizen should know about their duties. So that should be displayed as we have citizen charters. In the same way, the list of fundamental duties need to be displayed in public places. So every citizen should know what are their duties, not just their rights. They should be also aware of their duties. So there should be a display of fundamental rights. So these are the things. వాళ్ళు క్యాలెండర్లో ఫండమెంటల్ రైట్స్ గురించి రాసుకోవచ్చు, డైరీలో ఆవిష్కరణలో వాళ్ళ డైరీలో, అది గవర్నమెంట్ ఎంప్లాయీ కావచ్చు, ఎనీ ఎంప్లాయీ ఆర్ ఆర్గనైజేషన్ వాళ్ళ డైరీలో వాళ్ళ ప్రాథమిక విధులను క్లియర్గా పొందుపరచుకోవచ్చు. సో బహిరంగ ప్రదర్శన చేయాలి, ఫండమెంటల్ రైట్స్ని ఓపెన్గా పబ్లిసిటీ చేయాలి, అందరికీ తెలవాలి ప్రాథమిక విధులు ఏంటి, వాళ్ళ ప్రాథమిక హక్కుల గురించి తెలుసుకున్నప్పుడు అంతే ఇంపార్టెన్స్ ప్రాథమిక విధులను కూడా ఇవ్వాలి. That is one thing, display and publicity of fundamental duties. There should be a restriction on broadcasting of any content which is against the beliefs and sentiments of some sections of the people. So, because it is the duty of that broadcaster or that particular agency to see that the sentiments of the people are not hurt. So, many contents we see in serials or in any series, movies, we see most of the content which may sometimes hurts to the other section of the people. Such content should be censored, and it should be the duty of that following producer or director or actor to take that their action should not hurt the sentiments of other people. So that should be taken care of, because we are multi-religious, multicultural society. We need to be very cautious. So books and pamphlets are prepared to propagate fundamental rights. There are many organizations, NGOs, civil society groups who should come front and publish these materials regarding fundamental duties. Pamphlets or leaflets, books are printed and distributed at public places so that everyone should have awareness about their fundamental duties. One another recommendation is NCC should be made compulsory in all educational institutions. NCC is National Cadet Corps, because in our fundamental duty we also said that the state could ask for your service to defend the country. So NCC, they are like given a very good training in terms of military. So NCC should be made compulsory in all schools, colleges and universities. So that brings them a sense of integrity, a sense of fraternity, brotherhood. They would cherish the ideals of the nation. They respect the sentiments or culture of other people. That sort of broad-mindedness is created when there is a part in NCC, National Cadet Corps. Thank you. This was on fundamental duties. Please do subscribe to watch my more videos. Thanks for watching my video. Thank you.